many times.
Was it kept for the case diary?
No, everything. Charge sheet is available.
Was it kept for adjourn for the case diary?
In the week commence.
All right, give us the.
That's the adjourn.
My lord, I have filed a review petition, my lord's order of dated 28th October. My case is not covered under, but it is in disposed of.
My lord, it's
Two other contractors.
Please give your slip.
Yes,
From tomorrow onwards, procurement is petty procurement is going on, my lord, and around 1,000 farmers are being deprived, and they are not going to take
What is going on?
petty procurement.
What?
Paddy
Paddy.
procurement
Huh.
from tomorrow, and 1,000 farmers are being deprived, my lord.
Yes.
And I have mentioned before the concerned bench, my lord, whether they're not taking the memos, my lord.
File an appeal against that rejection order.
No, my lord, they're
So
going
what are you doing now?
my lord, to list this matter.
No, you are making submission as if you are preparing a appeal against the order of rejection of your mentioning.
No, I'm sorry.
What is this? That has been rejected. That has been rejected.
Maybe
This is my
let's say for tomorrow.
Don't do it.
this is
Yes, give your slips, please. Please give your slips.
Deleted mass. And maybe covered by my lord's order, my lord. Deleted, it was in list. It has been deleted, not listed. Only a pre matter deleted.
very matter. Often tribal by master. Petition is in 8 months.
Give your slip.
29 number of writ of writs arising out of single order is pending for 8 years on the question of maintainability. In view of section 100A of CPC, they are not maintainable. 29 number of cases.
You are the appellant.
Dues.
You are the appellant.
I am for the respondent.
So have you informed the appellant?
And
Have you informed the appellant that you are going to make a mention?
What is it, the state?
EPA, Provident Fund Council.
Yes. Give your slip.
I made
Matter on a lordship board. Item 14, on a lordship board. I'm praying for a short pilot accommodation, password is prayed.
Ask somebody to be.
I may be pardoned to mention member. This matter is considered a supplementary item 20. Your lordship has been pleased to direct the state government to file the counter. The tender is going to open today. So I filed the also the
It was there in the list yesterday.
my lord, item
Why did
20.
you not mention?
At 11 o'clock it was. I have quote note 12 at my serial number item
Okay,
5.
okay.
So may I please to take up? I have also filed the document lordship can pay it. The date is fixed to today, my lord,
So what?
for opening of the tender, my lord.
Two PM.
My lord,
Please inform the state.
My lord, I am supplying the it made the extra memo. I am supplying the same to you.
item 44 of the lease file. Cannot be reached, my lord.
Let it be checked. If it doesn't reach, how are you so sure that it will not reach?
No, this is a matter relating to dog inspector's examination. Dog inspector's examination, sir. Your lordship had fixed up this matter to be hard at 2 p.m. But somehow, my lord, inadvertently, it has not come, my lord, at 2 p.m.
The 2 PM when? Today?
Item number 44, it is listed there.
2 PM today or when?
No. It was there earlier. But
Let us try that the matter is taken up. Let us see.
item 24 not placed, my lord.
24.
Item number 39 of the admission. This matter taken concern, Mr. Senior Counsel is appearing this matter. I pray for 1 week after.
Which item?
39.
Ask someone to be here when the matter.
I'll be there.
39? This matter you made such a.
Yes,
yesterday,
yes.
you have
Mr.
fixed
Senior
together.
Counsel.
Today you asked for time.
No, Mr. Senior, we have engaged Senior Counsel. So, yes, sort of time. So, 1 week after.
Pending till 2016.
1 week after. I've taken concern.
No, we will not have them. Sorry.
Last occasion, the matter was going
Right.
to be disposed
Right,
of
right.
because he requested we kept
Right,
it
because
today.
the Mr. Senior Counsel is engaged. So, he is not, today is
Sorry.
out of
Sorry,
state.
this is not the way.
Orders. Matters under the heading for orders. Item number 26. Item 26.
Mr. Das, what is this matter? 26.
My lord, revenue officer Vargad rejected the claim of impact number 1. Appeal was allowed by the sub-collector. Against that revision was preferred. The honorable single judge, the lordship will find from page
No, but otherwise the application is maintainable or 227, it will not be maintainable. That is what I'm asking. It's a writ appeal. So is it against order?
of the regional authority, not whatever.
Today also there is no representation on behalf of the elder.
Last time there was.
This application, this appeal is dismissed. 44.
Item 27.
There is delay of 424 days and notice is already sufficient. For no counsel is required.
IA 2596 of 2023. As per the postal tracking report, the item has been, notice has been delivered on the respondent, but no counsel has appeared on behalf of the respondent. Hence, list this case for fresh admission. The IA for condemnation of delay will be considered on the next date. List the case for fresh admission on Thursday, on 12th.
Item 28.
There is delay of 547 days and on a time to file the certified document.
A time not been granted earlier?
Hello,
Had you not been granted time earlier?
earlier granted, but I had asked to file it in the e-filing center so that it could be available. But
Last for 2 weeks, 2 weeks time had been granted.
yes, ma'am. 1 week.
In spite of time being granted for filing of certified copy, the certified copy has not been granted. Full stop. IA has not been filed. IA 2596 of 2023. As per the postal tracking report, the notice has been delivered on the respondent. Full stop. No counsel has appeared on behalf of the sole respondent. List the case on for fresh admission on 12/12/2024. When the IA for condemnation of delay shall be considered. If the certified copy is not filed before the next date, the same shall be dismissed. The appeal shall be dismissed. Yes.
Item 29.
Delay of 543 days, my lord. No counsel is appeared so far. Okay.
Same order. Even though notice is IA 4019 of 2023, even though notice is sufficient on the respondent, the no counsel has appeared on behalf of the respondent, comma, full stop. Hence, list this case for fresh admission on 12/12/2024, on which date the IA for condemnation of delay shall also be considered. Yes.
Item 30.
Delay of 290 days, my lord. Imagine it's similar to 10th December, the contract pension.
10th December.
Madam.
Mr. P.K. Mahapatra, learned counsel appearing on behalf of the respondent submits that with appeal number 614 of 2023. Oh, this one.
Madam.
And this that data got the sorry. Mr. P.K. Mahapatra, learned counsel appearing on behalf of the respondent submits that this case is covered by a decision of this court in WA 1134 of 2023, but the same has been challenged by the state of Orissa before the Supreme Court in SLP number 2146 of 2021 and badge, full stop. The matters have been heard on 19/11/2024 and judgment has been reserved, full stop. He also submits that similar matters WA number 614 of 2023 is posted to 10/12/2024. Full stop. Hence, list this case on 10/12/2024 along with WA number 614 of 2023 and batch.
Item 31.
In this case, my lord, directed me to calculate the actual date of actual day of delay. My lord, that is stamp reporting is required, my lord. That the stamp reporting indicated that the date of presentation is 18/11/2024. But I presented it before, my lord, that is 18/7/2023. So that's why this is the whole difficulties of recalculation of
No, stamp reporter has calculated correctly. You tell us your calculation if you had filed the appeal earlier, because without the certified copy, the appeal is
My lord,
incompetent. That is why it is calculated.
180 days.
Otherwise, it will be 180 days.
18/7/2023, my lord, my appeal is before my lordship. I filed. But stamp reporter indicated that it is presented on 18/11/2024.
Was it not present? Did you not file the certified copy on 18/11/2024?
Certified by file.
That is why he has calculated. So have you stated that in your condonation of delay?
No, I have not calculated correctly earlier, but only I put my lord to delay which has been caused.
So you taking a cue from the IAS of the state, filed by the state.
Yeah, I have given the copy, my lord, already. For consideration.
Any private parties?
No, my lord. PSC only.
Yes, Mr. Das.
My lord.
And what is the matter? What is the merit?
My lord.
Regarding that recruitment, my lord, that is a scheduled caste portion, my lord. He has secured more marks, but that has not been taken into consideration. That was challenged before the learning tribunal. When tribunal is not functioning, and also that is
Which tribunal?
over. Thereafter, the matter was also transferred to before this honorable court. This honorable court, it was before the honorable single judge. While the matter was taken up, the Lord Council, without taking the consent instruction from the petitioner, that is said that it became infructuous. So that's why honorable judge passed the order that is infructuous. So that's why he
You could have
requested
sought a review. We will condone the delay, but we will discuss.
He filed a recall
Minor.
petition.
Minor.
That was rejected.
So that's why I am before my lordship.
Recruitment of the year? I think 2000.
On that day,
No, that day we have understood. Recruitment of the year. That is why the court said that it has become infructuous.
No, that is on merit, my lord, that is RTA also obtained the copy. So that's why
RTA.
it is. But
The case is based on RTA.
so such question paper is there and the answer paper is there. I have also annexed. So that's why I am not.
Recruitment of which year?
13-14.
2013-14. 10 years.
That is relevant
Which
time
post?
eligible, my lord. And then 13-14, my lord.
Which post?
Post for the Ayurvedic doctor, my lord. My lord said that's why I faced the recruitment test.
And when was your writ petition dismissed? When was your writ petition dismissed?
Dismiss, my lord, not to dismiss, honorable, I think was the case, it is infructuous. So that is the first, 24/8/2022, my lord, the previous counsel was there. That his junior also saying without taking instruction, said that it is the infrastructure. That's the on 24/8/2022. As a appropriate, it is
Has
not
he filed any affidavit that he had not taken instruction? The lawyer is there.
My lord,
The lawyer, this is the statement of the client that no instruction. We should issue notice to him then. The lawyer.
that's came as a-
Why? How can he blame a lawyer?
No, my lord, is it client
And
is-
why should we accept his statements without issuing notice? Implead him party. Implead him party. Not the way. But cases. Anyone can come and say that I had not given instruction. And the case was argued incorrectly.
He said that it is infructuous matter.
What infraction?
It is 68 matter of the order of honorable.
Why, how? You are blaming a lawyer.
No, not blaming.
Yes, you are blaming.
No, not taking the
Listen,
instruction.
you are blaming. The entire blame is on the lawyer. What are you saying? It's not a very simple thing.
Instruction.
It's not that easy.
Infructuous, it is.
Very good. So he did not seek any instruction and said that it has become infructuous. And now you have been engaged to say that he did not have any instructions. Very good. All right. Where is the proof? If you want, you can implead him. Well, learned counsel appearing on behalf of the petitioner states that learned single judge passed the order recording that the writ application.
Sorry, my lord.
Just one moment.
Mention.
My lord, yes.
Yes, 16.
Yes, yes, yes. Sixty-eight. Page 68, ma'am.
So false according to you. So he'll have to be, in fact, the client should have taken action against him before filing recall petition or writ appeal.
The same counsel had filed stating that it was inadvertently stated, one can understand. Somebody
Matter would have
coming
been
and
different.
blaming him. So you take instructions.
As you wish.
Because you are blaming
No.
Fellow-
That is the statement of.
Brother of yours.
I'm not blaming, that I'm sorry for this regards, madam.
Sorry. You have filed the writ appeal. You have filed an application of recall.
This recall method,
what was stated in the application for recall, that he filed or you filed?
recall I filed, ma'am.
Very good.
He not. So that's why after.
This is not done. We discourage this practice. Yes,
I'm not pressed, madam.
Learned counsel appearing on behalf of the appellant after some argument
After litigation, not pressed.
states that he shall not press the appeal, but seeks liberty to pursue his remedy before appropriate authority, if appropriate authority, if available. So this appeal is accordingly dismissed as not pressed with the aforesaid liberty. Here.
Item number 32.
Yes, right. Deleting. Yes.
32.
Item 32.
Matter has been listed on no order. None appeals of the petitioner when the matter is called. This appeal has been listed on the basis of a mention memo. But since certified copy of the impugned order has not been filed, nor any application has been filed for dispensing with filing of certified copy, stamp reporting of the case has not been done. In order to give another chance to learned counsel for the petitioner, list the case on 12/12/2024. Certified copy shall be filed before the said date, positively, without fail. Yes.
Item 33.
There is delay of 103 days. Notice from respondent on return with noting that he has left place. So fresh steps against respondent 1 to be taken. And correct address of respondent 3 and 4 be filed, for which I prefer 1 week time.
All right. In view of the report of the registry, Mr. K.C. Kaur, learned government advocate, prays for how much time? 2 weeks time to take further steps for issue for service of notice on the respondents. List the case on 12/12/2024.
This one. Item 34.
I pray for 2 weeks time to file counter on the question of limitation. But 2 parallel proceedings are continuing.
What is the delay?
Delay, as per me, nothing matters because it was communicated to me and within the month I have filed the return.
What is the delay? You may
Delay
say
as per
that
the
as
stamp
pointed out by the stamp reporter,
But
this is the
266
delay.
days, man.
This is what you could have said.
But let's kindly see.
Yes.
Huh.
Yes. When we are asking what is the
Yes.
delay pointed, you have to point out. Thereafter, you'll give your explanation.
Yes. Let's kindly have a look at annex 8 of 56.
The application.
Yes, ma'am.
Because you were not a party before the single judge.
Yes, I
In
filed.
fact, that is the basis of your appeal.
Yes, I filed.
Where is it?
It is IN number 8/228 of 24.
So you must have filed yesterday.
No.
Then
I have filed same
okay.
27.
You've served a copy on Mr. Kaur?
Yes. I'm sorry. 20th minus. I have
I
filed.
will file counsel within 2 weeks in a detailed manner so that the cat will be out of the bag.
So cat will be out of the bag means he wants to be implicated as a party because the order is affecting him or the appellant. So for that, can you have any objection if he's heard?
The matter is still sub judice before the learned deputy director come ADM
No,
to
that is all right.
same on the
But
same point.
you had filed the writ petition
And
without impleading the appellant as a party. So if the matter was sub judice, why did you come up before the High Court?
they were added, the matter was had.
All right. We're granting you 1 week time to file an objection.
I will file counter within 2 weeks
Counter to what?
regarding limitation.
You not, it must take the application file, he said. So then we allow him to be implicated as a party to the condemnation of delay, you can file an application, objection. All right. IA. Yes. IA 8228 of 2024. Although this application is not listed today, but the IA has been filed on
20th minus.
20th
September.
November 2024 and is available in the physical file. Copy of the application has been served on Mr. P.C. Kaur, learned counsel appearing on behalf of the respondent. Full stop. As the appellant was not a party in the writ petition, we are of the view that leave to appeal should be granted to the appellant to pursue this appeal. The IA is accordingly allowed and disposed of. List the case for orders on 12/12 2024 to enable Mr. PC Kaur, learned counsel for the respondent, to file an objection to the IA for condonation of delay.
Retention was made as a party. They did not, they appeared, but did not contest. For which the.
Is that a fact?
No,
Yes, madam.
the read petition, lordship, I can see the order.
That's it.
I am concerned with the read and read.
No. Your lordship may see the impugn order of the assistant.
See, when the matter was called out, you short time,
No, madam, he was a party.
and now you have started making your submissions.
No, he was
We'll hear you.
he was a party before the Honorable High Court.
Yes, you please check this so that next time you make your submission. This is the cause title of the writ petition filed by you, they did. Yes, next matter.
Item 35.
Petition to condone the delay in that case. The delay is 67 days.
Condone the delay and fix the date for it.
What is the subject matter
Regarding regularity.
regarding
Regularity.
IA 5650/2024? This IA has been filed for condemnation delay of 67 days. For the 67, 67 days in filing the writ appeal. After hearing learned counsel for the parties and considering the short period of delay, we are satisfied that this is a fit case for condoning the delay in filing the writ appeal. The IA is accordingly, the delay in filing the writ appeal is condoned. The IA is accordingly allowed and disposed of. This is the case for fresh admission on 12/12/2024.
Copy of the appeal memo, sir.
Copy of the appeal memo may be served on Mr. S. Shekhar, learned counsel, appearing on behalf of the respondent by 18th, by 2/12/2024. All right.
65.
65, 65. Thank you.
Item 36.
It says, my lord, there has been a delay of
Take it.
170 days.
They have already implemented that, or into has already implemented.
Implemented, you must have filed a contempt.
No, they have filed a writ petition
No, without filing a complaint, they have.
because the original order passed with the London State Execution Tribunal.
Yes,
Thereafter, state file appeal on imposition court.
yes.
That the FAO has been dismissed. After dismissal of the FAO, now which is under challenge with lordship, they have the present respondents have filed a writ petition seeking implementation. In that writ petition, they have implemented and also given an undertaking to pay the area.
So you had filed a writ petition seeking implementation. So notice had been issued to them.
Yes, all their instructions.
Okay.
And apart from that, this is a writ appeal against the order passed under section 24C of the Odisha Election Act. Appeal is also, integral appeal also not.
So that matter, I think. you have to
Why?
consider.
Odisha,
Under section 24C, the single judge, when deciding the matter of
that FA.
FAO. Now, apart from that, already implemented.
Have we decided?
No, not decided, will decide.
Your lordship probably fixed to larger way, but apart from that, already this case, they have complied. Lordship,
Yes, you have told complaint twice, you have told, we remember. But that is why we were asking why they have complied and thereafter filed. And anyway,
Yeah,
that matter is pending, which will be decided by a larger bench.
Yes.
I am
And
thinking, my lord, possibly,
So if you have been implemented, you enjoy that. Whatever happens later, we'll see.
I think, my lord, I am not sure.
Yes.
My learned friend said that it is implemented. Possibly, I am thinking, after filing of the writ appeal, they must have.
No, same.
Because
same day.
from the same school, some teachers are given the benefit and this respondent, he was not given.
No, since that
Subsequently
matter
was
is to be decided whether regarding maintainability of the appeal. So let us see.
That's that order they also.
What is it that for substitution of paragraph 4?
Yes, my lord, your lordship may kindly pardon me. Para 9, your lordship may kindly see. Para 9, which is available at page 8.
What happened? Copy paste problem or what?
Judgment has only cross mark has been given, that ordering portion has not been given. That is a mistake. That is why I have filed the IA. In that IA, the order is that is to be incorporated.
For substitution of paragraph 9 of the Writ of appeal.
That is in IA 5971.
Paragraph 9 is in the following direction that
All right, you will list it soon. This matter will be taken up.
this we are allowing in that paragraph, I forgot to write. IA 5971 we are allowing. One place they've left it blank. IA 5971 of 2024 for substitution, this 5971 of 2024. This IA has been filed for substituting paragraph 9 of the writ appeal with what? With what? Substituting it with what? You given the
Entire para 9.
paragraph 9 with what?
Para 9, in that para, the judgment has not been reflected. That portion has been left.
Only a schedule is there.
Yes.
As per the schedule.
Yes.
Considering the amendments made in the IA and the submission of the learned counsel, we allow this IA and allow paragraph and direct that paragraph 9 of the writ appeal shall be substituted as per the schedule in this IA. The consolidated writ appeal shall be filed by 3/12/2024. This is the case for order. There's a condemnation of delay. This is the case for condemnation of delay on 5/12/2024. So you file it by 2. By 2/12/2024, list it on 5/12/2024.
Those cases also only refer to the adjournment.
No, this delay has to be condoned, that has to be done, that is why these formalities.
37.
May I please, Malad? Malad, here the intervener in the rate petition is appellant before your lordship, Malad. Last occasion, the above matter was listed. I have take liberty to file an IA for grant leave to file this appeal, Malad. I have filed and that is at annexure, that is at flag C, Malad. IA number 8286 of 2025. Here, Malad, without giving the opportunity of hearing, the honorable is pleased to dispose of it.
Yes, voice for the other side.
That state and other private parties are, opposite parties are there, my lord.
So what was the final order passed in the writ petition?
Yes, my lord. Again, my lord, during pendency of the writ petition.
Again?
Sorry, ma'am. During pendency of the writ petition, there was a demarcation.
No. What is the order which are agreed by?
Yes, ma'am. Kindly have a glance to running page number.
And who are you?
But I am one of the villagers, my lord.
One of the villagers?
Yes.
All right.
Here, my lord, what happened, my lord? Under a government project, there was a construction of community center under a government project, my lord. But my lord, one of our villager, he made a complaint that for the construction of the said community center, his ingress and egress will be hampered, my lord. Thereafter, he filed the writ. During pendency of the writ petition, there was a demarcation.
Just a minute. The operative portion of the order is.
Yes, my lord. Running page number.
Disposes of the writ petition with the direction that demarcation of the land shall be made by the Tahsildar in presence of the petitioners and the junior engineer.
That has already been done during pendency of the writ petition. Without going through the counter filed by the state, this order has been passed, my lord.
Just a minute.
Pardon,
Did the state file any appeal? Whether the state has filed any appeal?
no, my lord.
No.
Yeah, my lord.
How many villagers are there?
In the writ or
No, total in the village. How many villagers are there?
that, my lord, I have not calculated.
20,000?
No, my lord. Yeah, in the meeting, there is a meeting, my lord.
No. What is the population of that
Population, my
village?
lord, I will take it.
No, let's say more than 50.
Yes, my lord.
So each villager will come with one petition.
One person, three petitioners who filed this writ petition, they have filed a petition, they have problem.
All right.
Then what is your problem?
So if the villagers, you file an application for intervention
My lord.
only on the ground that you are a villager.
No, we are the villager and we are in the said meeting, we are present there.
Which meeting? Therefore, you become a necessary party.
Yes, my lord. I want
because
to
you were
highlight
present
that.
in the meeting.
I want to highlight. But initially,
We understood. You tell us if I'm wrong.
They will pose cost. So when do
initially
you
there
want-
was a meeting.
Just a minute, we will hear you on merits. When do you want?
Merit, my lord. Then,
No,
my
no,
lord,
when do you want hearing? On your.
next week, my lord. I will prepare a short,
we
little
are-
lots of submission, my lord.
We are prima facie of the view that the appellant did not have any locus standi to maintain his intervention application before the learned single judge. So stop. The appellant has filed the present appeal assailing the order of the learned single judge on the ground that he was not heard. So stop. List this matter on when?
Monday, my lord.
On Monday as the first case.
First night.
We are cautioning you that if
Yes,
we are
yes, my
not.
lord. I have documents, my lord. I will
Yes,
just translate
we
it,
are
my lord.
cautioning you
My lord.
that if we finally reach a conclusion that you did not have locus
No.
standi and you had
No, my
intervened.
lord. I have documents.
No, you should be ready for payment of cost. You can tell your client.
My lord.
Item 38.
There is a delay of 142 days in filing appeal. IA number 8045 of 2024 is at flag A.
Just delay fine, 147 days. But what is this appeal maintainable?
A challenge to order of honorable single judge is that case 71,
Okay.
wherein I have taken the government regarding the arbitration, award of arbitration has been passed in respect of the vehicle.
Okay.
It has not been considered and directed for release of the vehicle, madam.
All right.
No, you had. Who has filed this?
Madam, the financer has filed this appeal. The customer has filed the writ application before the.
So on what ground are you challenging? Why you agreed by the order? You've been asked to pay.
Because the vehicle has already been sold in view of
Okay.
arbitration award, your lordship.
Issue notice.
All right. Issue notice on the, how many respondents? One.
1 month.
Issued IA 8045 of
Second
2024.
respondent is the RTO, madam.
All right.
Two respondents are there.
Issue
Mr.
notice.
Prabhakar, where I will
Issue notice on the question of condemnation to the respondents, full stop. Notice on behalf of respondent, no, a copy of the IA may be served on Mr. Prabhakar Behra, Learned Counsel, and Learned Standing Counsel in Transport, who, on behalf of opposite respondent number 2, full stop, requisites for issue of notice by registered post or speed post with AD on respondent number 1 shall be filed by within a week. Within a
by
week.
tomorrow, madam.
All right. There's some urgency.
Madam.
By tomorrow, notice shall be returnable list the case on 20/12/2024. Notice shall be made returnable before the next date.
Before.
29, 1911, 1912. Okay.
Orders not to open. Item number 1.
Yes, what is the progress?
My lord, directed the PG and the NIC official to be on online so that subsequent, yes. Right, your lordship, regarding development.
This one.
Yes.
With all of this.
So 10:30 also point out for the. All right.
Yes. Yes, who is online? Who has joined online?
Sir, good morning, sir. I am DG Prisons, Odisha.
Okay, what's your name?
Sir, my name is Arun Kumar Rai, sir.
Arun Kumar. Yes.
Sir, we have received your orders. We have worked on this. In the supplementary budget, we have asked for the funds. We have worked out the game plan with the NIC authorities and we'll get it implemented in 4 months. Only thing is that the cost, NIC works on the pattern that to pay the funding in the beginning. So I've already discussed this matter with the Home Secretary. The funds will be placed most possibly in the supplementary budget and we'll start working on this so that in the next 4 months we can get it implemented, the portal.
What is the budget tentative?
It's about 2 crores, sir.
Only.
For 2 crores.
This is for the phase 1, sir. As we work out on the phase 1 and then the Honorable High Court has given about 4 to 5 data sets to be put into the citizen portal. We may be able to put more data sets so that we are more transparent as is the desire of the Honorable High Court.
Have you filed affidavit? Is it at like 191?
Yes.
That is affidavit.
Affidavit is dated 14, my lord. Lordship, is the last order, 21/11/2000.
No, whether any affidavit has been filed thereafter.
Thereafter, Lordship did not direct, they will be filing affidavit.
Mr. Mishra, there was no direction for filing
No.
affidavit. Just ask him to join.
No, we are just, yes.
All right, all right.
So we just file an affidavit to this effect only, what you are saying. We will incorporate
Sure.
that in the order and accordingly we will adjourn the matter to be taken up after 4 months. But in the meanwhile, you must ensure that everything is done. Yes, Mr.
Sir.
That
On a
can-
side note, if I can be allowed to digress a bit here. What I hear is that the High Court has come up with a good portal for internal mechanism, grievance mechanism of its officers. And I'm told that it's working very well.
Yes.
And that has come about, I think, it's come about quite quickly, I believe. So because this also involves the Legal Services Authority. So I think 4 months is something, this is doable, and 2 crores for government.
Let them do. If they do it within 4 months.
You're saying 2 crores is nothing or, I mean,
No,
No, I'm saying that
for 2
since-
crores, why such a long time?
that's one. And second is, if this is actually completed, then a major burden of this litigation, everything, the judicial time of these judicial officers who visit every month, all that would be synchronized in one go
It will also be convenient for them.
for them. And I think the High Court portal has come about in quick time. I'm not sure about the.
Yes. That was not a.
That
very big
technical,
thing.
if it's about technical know-how, I think it's not much.
No, our team. Our team
And
did
our
it.
team did it also, didn't
Yes,
High
so
Court
I think that's
program
not
it.
something in today's age. This is not.
But they will do it through NIC. NIC.
Well, I do appreciate there would be security concerns and all. But if the High Court could do it so quickly, I think they can take a leaf out of the High Court.
We can do it for them now.
Yes, in fact, the national, the legal services authorities are involved in this. They would be a major stakeholder in this data input. NIC being a pioneer in this, they can
See, in the our High Court, our programmer and CPC, they did everything.
Yes. So
And every information about all the judicial officers of the state is available.
and that's a system which is, I believe it's working well. So we can just have that kind of a. I don't think this is something which is. It involves the legal services also.
Let them do the way they want. But just file an affidavit we will incorporate in our order, and we will issue directions accordingly. The other thing which we wanted, since you are present, Mr. The IG President is here, that you don't have any open jail in the estate.
One, there is
So-
one.
Huh? One
Just
open jail.
The name, I mean, just like that, it is not open in the real sense. Mr. Rai? I think they are muted, we can't hear them.
DG please.
Are you muted,
Yes,
Mr.?
sir. No, sir, I am able to hear you. I am able to hear you, sir.
Do you have any open jail?
We have only one open jail at Jamujhari in on the outskirts of Bhubaneswar.
Jammu jail?
Yeah,
Place where I had
it
gone.
is called open jail, but is it actually open? Yes, that.
That is the place. No, Mr. I had visited that place.
Sir,
That is not an open jail. That is maybe model jail. It's not open. What is the concept of open jail?
open jail, my lord, the concept is very simple. In all other prisons in Odisha, they are within 4 walls. They can't go out. Here we don't have a wall across the compound where they stay. And they do farming activities, they do dairying activities, they do all kind of dari making, other thing. Evening they have kirtan, all kind of religious festivities are going on there.
So you can, that is not an open jail. Open jail is a concept where and you can find out from other states also
The night to rest, but otherwise during the day
that
they can move.
they are allowed to go out of the out of your normal jails. They remain in the open jail. They go to their families, live with them. They do the household work, and then they return in the evening and stay in that open jail. So this is how the process of integration happens with the society.
Sir, I have noted your directions. I'll immediately set to study on this and improve the open jail to the degree that the honorable court wants.
I have seen, in fact, what you are calling your open jail. In fact, in the there the prisoners are locked up in the evening, in the night.
In the evening, sir.
They are.
Then they will go back to the family.
They don't go, no.
In the night.
Inside, no. In the night. No, in the night they should not go. In the night they should stay. In the morning they can go.
The morning they
So
go
this is
The morning they
No,
will
no, I interacted with them. I was there with them for quite some time. I interacted. They had so many grievances.
What is the model?
Look,
Should be the concept.
have we worked on this in this proceeding?
In fact, the system which is governing our state is Rule 846 of the Prison Manual, which defines how it would come. So the timings are given. So if that can be shown, otherwise my
I think
lordship.
you joined the post recently. Mr. Rai, when did you join this post?
Rule 846.
Recently?
Sir, 2 months back.
That's what I.
I joined a couple of months back.
Rule 846.
But I've taken note of the court's direction.
No, you should
We'll
work
get
on
to
this.
work on this
This is
immediately.
very.
Should be a model jail for
This is-
the entire country to emulate.
And if you plan, we must also point out, and you should take up this matter very seriously, that if you decide to have open jails, then you should not have only one in the state. You will have to have at least one in each and every district. All right. So, like when you develop a kind of confidence in a prisoner, that if he is allowed to go out of the prison, he will not escape from the process of justice. So, in such prisoners may be allowed to go out of prison, stay in the in that prison, open jail. They may go to their families, they may live with their families, and they return in the evening. So that this can continue for 6 months. Thereafter, they may again come. Let us see. This must be there. 846.
846. Their prison manual. prison manual.
Jail manual ಮುಟ್ಟವಾಯ್ತು.
Oh, this is something different. Open air jail. This is open hallway.
So under that chapter, this 846 gives the timings, and prior to that, the classification who can stay. The previous page, the thing begins.
No, this is open air jail, you're right. Open air jail.
842 onwards, it begins. Under chapter 33. Open air jail and open colony.
Open?
Chapter 33, 842, my lords. Need for open air jails is the first, 842 is the.
Where is the open colonies?
My lord, may see chapter 33, the chapter. is
33, we are there.
Under that.
There are two concepts. One is open air jail and the other is open colony.
Yes.
So where is that open colony?
Then 842 below that, your lordship will see, they deal with them together. All open air jails and open colonies are intended to practice the contemporary ideology of reformation, correction, and rehabilitation.
And Mr. Rai, in a lighter vein, you are saying there are no walls in that jail. So if the jail is a model jail, people from outside may come and stay there. So I think you need some security.
Ma'am, we do the screening and then we put the prisoners there. The prisoners who would not have a propensity to escape are placed there. But at night they're put into the barracks and locked. But otherwise the jail is without a boundary.
But you're saying there is no wall, then what is the necessity of a gate?
See, 856.
The gate is only for normal purposes. It is not for the purpose.
Mr. Rai, based on my personal experience, I am giving you an example. There is an open jail. You can call that open colony under your prison rules. Buxar in the state of Bihar. So that is an open jail. Open means there they can go to their houses, but the population in such in that jail is less because there is only one in the estate. Therefore, the prisoners of different districts may not like to come to the that jail. Therefore, the population is not and that system is some challenge. But you can just examine and if open colony, the inmates who have already spent minimum 3 years at open air jail may be considered for transfer to open colony. Please examine that.
Probably they don't have an open colony system here. Only, and under section rule 3ZG, all three have been defined in one clause. What are these meant to be. In this manual only they have defined, and as your lordship says, 856 gives the exact parameters which your lordship.
No, but here there is some difference. I may have been wrongly informed, but this is my idea about the jail which is there in Buxar of Bihar. Please examine. We are keeping this matter after 1 week. On the next week, we shall be passing orders on this today's. And in the meanwhile, Mr. Rai, please examine that concept. So if you can introduce
Yes.
that will be a very good initiative. That will
Correct, sir.
take care of such jails which are overburdened.
Can I request that 4 months, if that can be?
No, let him file an affidavit, thereafter we'll pass the order.
Mr. Anil Kumar Rai, the IG Prisons has joined.
IG or DG?
DG.
DG
Sorry,
Prisons.
DG of Prisons has joined the court proceedings online. Stop. I'm referring to the previous order of this court dated 21/11/2024. He has submitted, based on the interaction which he had with the NIC officials, that it will take 4 months time to fully implement, to make operational fully, a comprehensive web-based portal with AI-enabled features for Odisha prisons. So stop. He has stated that steps are being taken for allotment of fund of rupees 2 crores in phase 1 for the said purpose. Stop. Next. Let an affidavit be filed on behalf of the opposite party, on behalf of the DG Prisons by next Thursday in this regard. Next. Open air jail / which colony is that? Open colony / open jails. The court further expects that the DG Prisons shall in the meanwhile also consider the feasibility of having more open air jails and open colonies / open jails in the state of Odisha. Just examine, find out how does that function? This is my based on my experience, and this is my idea about that jail. And I find again, this may be my personal view, and I'll not go by what I feel is correct. I'll certainly depend on what submissions are made and what you suggest. That's a good idea. That if the prisoners are allowed to interact with the families, that will introduce a kind of discipline also among them. You will have an opportunity to watch their conduct for so many things. That will be very helpful. Just think over.
There is a famous Bollywood movie, old movie by V. Santaram. Do aankhein baraat lordship, I have watched that. But your lordship is again expanding that.
We will have to see. We will have to be systematic in our approach. So whatever you take a policy decision, you implement that. Your policy may be defective, our policy may be defective, but we shall learn by experience.
By that,
we can learn by
the
experience.
leading state, my lord. If
So
this is implemented, Odisha will be a model for
This is. Yes, open conference. No. Yes, this is what I'm saying. Yes. So this is what. The workplace within 5 kilometers radius. So we are allowed to have sales counted near us. It will be the country 30 days. Please examine. That's a very good idea. And its state can afford that.
So that would not be a problem, sir. We have sufficient resources now, sir, and we should be able to implement, sir.
In fact, it will be cheaper for them.
Yes, and please work out.
We have at least 33 such open jails in the country.
In fact, Madam has got this information about Patna, Buxar jail also. Yes. Next.
Item number 2. Item number 2.
Pursuant to Locus order, we have published that list in the website, my lord. And we have filed an application seeking leave of the Honorable Court, my lord, to grant us permission so that we will be able to, my lord, communicate with regard to our earlier decision. We want to recall.
Have you served a copy?
My lord, I'm giving you.
In the last occasion, your lordship directed me also to file an affidavit stating as to how many persons have been appointed.
Just one moment.
The DG present online.
Next date.
That is more helpful.
Yes, sir. Yes,
Lordships, may I have a say? Lordships, we filed an information in this application.
In this case,
Yes.
should not have filed.
Your Lordship, there is a reason.
Because we were facing trouble because of your absence.
No, Your Lordship, I don't.
All right, now you have come.
In your absence, we could not have passed any order against you. Now.
No, Your Lordship, the only concern that we have is that I was selected in the first list. And if your Lordship remember, last time it transpired, there were 5 people who were later sent. So our name was missed, but we were later sent. That's our case. Because they made a wrong application of how the horizontal reservation for women has to be made. So my name was left out, and thereafter I came. Now, your lordships, in none of these appointment letters, we were ever told about any of these litigations. And we have worked for 5
No, we will
years.
try. We are finding it very difficult. It is not that we are not inclined to protect your interest also, but at the same time, we have a duty uh, to enforce fundamental rights of those who were more meritorious as per the revised list, but they could not
May I-
get
may
employment.
I just,
How you
this
were
is in
recruited.
fact, this is a service matter. So your lordships, relief can be confined to the petitioners who are there. The problem is that the original petitioner, because of her, the whole revised list came up. She never made any of the people party who should have been made party. And I think there's a long judgments also, but you should have made them parties. So then I think they would have been her, and this problem today would not have arisen. I think that bench would have been more than conscious that yes, I have to take a final decision not only for one person, for everybody.
I think you should be happy that you were not treated as a
I
party
understand,
because
but today,
you will not have
today
been
I
allowed
have,
to continue.
today I do apprehend some kind of unhappiness, and that's why.
No, we are there. We are trying.
so
We are trying to protect. We are trying.
Lordships would tell them, because there would be posts, and I think Mr. Samal's client also can be accommodated.
No, we are not here for accommodating someone, but see, you have been working since long.
And we've left
The-
other opportunities here also to be here. That's also the.
Working since long, that is one aspect. And the other aspect is that persons above your, of better merit have not been selected, have not been appointed.
There are only
how to-
little marks difference, to be very
That
honest.
is the immaterial. The
Yes.
point was 001 is
I
makes
do
the
agree,
difference.
but still the relief can be confined to the petitioners also. I think there are posts.
that will depend on what Supreme Court says in such circumstances.
There are judgments to that effect also.
We'll
The
see.
relief can be confined only to the people who approach the court of vigilant about it. And so
We
that,
will see.
and the original judgment did not
We
ever
will-
think of.
So an application has been filed seeking leave of this court to take a decision. So let them take a decision. Let us see what application. When did you file the application?
My lord, it's there, my lord, 8298. I've given a copy, my lord.
When did you file?
Yesterday, my lord.
All right. You have received a copy?
Yes, just now I have filed.
Give copy to her also.
I'm pretty conscious that my name would not be there because I'm aware of the new cutoff.
All right, you are there. You are working.
Working 5
You will
years.
see what can be done. When is the next election? When is the next selection for the post? Is there any requisition?
The government have not sent any requisition.
Is there any vacancy?
That government will say.
Now I don't have any instruction.
Already 23, the post advertised was 190 or some 90 post. 81
Mr.
candidates
Amal,
in 2023. There was an advertisement issued by the OPSC for the same post in respect of about 190 posts. And out of that, OPSC has recommended 81 candidates.
you will see.
Therefore, there are vacancies.
As per the court order, 2 vacancies.
As per the order of the court, 2 vacancies are still there for the respondent number 1 of each of the cases. That is the interim order passed by the earlier
Not a single judgment.
by the learned single.
You will see.
Those vacancies are
You
there.
will see. Just go through this application and assist us as to what order should we pass on that.
Yes. I will assist you, Lordship. In presence of Mr. Secretary, I want to clarify one thing. There is a previous merit list that contains the name of 940 student candidates. When they revised the merit list, it became 1004.
That is due to, sir. That is due to
Everybody's
court
name.
cases, sir.
It cannot be 1004. And some of the candidates, those
name has been recommended by the OPSC, their name has been incorporated in the list. Suppose in the 2023, OPSC has recommended a particular candidate's name for appointment to the government, but her name has been found place in this list also.
But you are not aware that who has joined.
Sorry?
No, but subsequent revised list, why should the name not be there?
Yes.
Because fresh marks for all the candidates, whether they have joined or not joined.
Already
Yes,
appointed.
doesn't matter. This is the complete merit
Revised
list. So all the names will be there.
No, we have not been, I have not been able to understand what you want to convey. This relates to which selection process? 2022?
This relates to 2018 selection process.
18 selection process.
My lord.
So why are you referring to 2023?
Now they are submitting the revised list in the website in 2 days before. Some candidates who have already recommended by the OPSC for appointment, their name has also been mentioned.
Yes.
Why will that not be mentioned?
They have already appointed in by the state government.
Yes, it is the entire list. That is why we were discussing.
It is the list they have not
not the
made any
select
press recommendation.
One thing is hiding. There is a stipulation in the advertisement who are the candidates who are eligible to appear the test. Some candidate made application. Those who are not eligible to appear the test or sit in the written examination. But somehow they have been allowed by OPSC to sit in the examination without scrutiny. But when the mark was picked up, they prepared a list and they found X is not eligible to sit in the examination, but he has sat in the examination. Her name has not been mentioned in the pre-revised list.
If this is a new controversy which you are
because of the fact they have mentioned the name. In the present
In
list,
mother language Odia, those who are not
in
passed.
the present list, they incorporated some candidates' name, about 17 candidates above me, those who are ineligible, and they secured good mark. Because of their ineligibility, the OPSC did not mention their name in the previous list. Now, if they were ineligible in that list, how could be they eligible in this list?
How or not is different. So you'd say who are ineligible. If you say,
Yes.
then that will be considered influence.
17 candidates.
Yes, my lord.
Above me.
My lord.
Above me, 17
This
candidates.
cannot be an endless litigation. Now you are saying about 17 persons whose results have been published. According to you, they were not eligible. Then those 17 persons will have to be heard.
No.
You know.
They are not eligible, but names.
They are above him. So for everything without hearing, that is the whole difficulty, that we pass orders without hearing the other side. We'll see.
There is no question of their appointment because they are not eligible.
They are not eligible. In the previous list also,
No, we understood.
which was published.
We are saying there are some candidates in this list who are otherwise not eligible.
Right.
And that I don't think the names have been recommended or can be recommended.
Yes.
Yes.
But their serial number has been mentioned above me.
Because they produced all
Yes.
the entire merit list they have produced. Not
Are they not
candidates.
eligible? Are they not eligible?
You check.
Yes, sir. Sir, we have sent some candidates were allowed to sit because of the order of the court, or no tribunal was there. They don't have they might have not the ODR test pass certificate, they have sat and they have, when they appear the examination, their mark is there, sir. And we have, when the total list is, their mark is there.
The mark is there, but we have taken them out.
Well, just see the idea and then.
What he is saying, please see. Because he says if they are not appointed, his position will go higher up.
We give it
Let him
affidavit, sir.
with regard to
Are you
that.
not aware? Does he have to give everything?
I have objection to your serial number 3622.
All right, file your affidavit. Application by the year number 72 has been filed on behalf of the OPSC seeking leave of this court to
Recall its earlier advice.
to
Recall its earlier advice, not to answer to those 11 things.
to recall its earlier advice. Which one? First one.
Yes, ma'am. We had written there.
How can you recall the entire earlier advice?
Earlier advice of 11 candidates. Of 11 candidates.
Advice was in respect of those 11 candidates.
11 candidates.
Confined to them.
Advice / a recommendation made to the state government for appointment to the post of dental surgeons. Dental surgeons pursuant to advertisement number.
Advertisement number 15 of 2017 and 18.
2017 and 18. Copies of the said application has been given to the Student Council for the respondents. You have received. You are paying for the respondents.
Number 1.
As well as the state of Odisha. So, a copy of the said application has also been served upon Mr. Senior Counsel appearing on Senior Counsel who has appeared on behalf of interveners.
How many? One.
Of an intervener. Stop. List this case on 1 week.
Not on 9th, 10th, 11th. I won't be there.
All right.
Any
Any day thereafter.
1 week comes to 5th. So 12th?
12th.
13th.
13th, all right.
13th is Friday for this matter.
13th. 13th will not be good. Friday.
16th.
16th. 16th. 16th. Within first 5 cases. Candidates whose names were required to be recommended but could not be recommended.
Yes.
It is there in this application.
Previous affidavit.
For the parties shall be at liberty to reply to the said application. Said I number so and so. Stop. An affidavit is also intended to be filed on behalf of the state. Complying with
Already filed.
Yesterday.
has been filed online yesterday. So stop. List this matter on 16th.
One thing only left. They have supplied the merit list, all other things. Only the recommendation of the OPSC to the state, that is only lacking. That your lordship will know that these names has been recommended at letter number so and so by the OPSC to the state. That document is lacking.
Which recommendation?
We OPS have recommended some recommendation at different times. 4 recommendations have been made in respect of this transaction. Which recommendation? Whose
So,
name has been
so not
recommended?
one document, whatever recommendations they have
Yes.
made, all the recommendations.
Yes.
Mr. Samal would generally practice in civil side, it seems.
This is required only for this reason.
You're right.
For this reason. The secretary on the other day submitted.
That was on a lighter note, Mr. Samal, and
No, submitted that X has been.
because of your tenacity and perseverance, this remark came.
Okay, Your Lordship. Secretary has submitted that on after 2022 July, we have recommended the name of ABC. That has not been recorded, but he made the statement. I verified those candidates. Their name has been recorded much prior to that. Therefore, it is necessary. Suppose OPSC in respect of 100 posts recommended on so and so date. In respect of 5 candidates recommended on so and so date.
Those are there on record.
That is not on the record.
5 candidates, that is there.
No, the original records were here. They've been seen.
Only one recommendation in respect of appointment in respect of 171 is there. There are.
All right, what I would suggest that you scan everything.
Yes.
And keep that in a pen drive. All right. Except confidential things that you are not required to disclose. So such things which should be in public domain, you keep that. Whenever that is required, we can see, and anyone can see.
Yes.
So just exclude the confidential part. You have the right to keep so many things confidential. We will not compel you to breach that.
Secretary will be, my lord. His presence, my lord.
When you are here, it is easier for us to. It is not that. Initially, we were very unhappy.
Records should they be? Records.
He should.
Be there, otherwise the records also in case we want to scan something.
Keep the records, one pen drive. If someone wants some dispute, then we can show.
So your records and the scanned documents which we can peruse. And if you want.
Which anyone can peruse. One which anyone can peruse, like public, that can be the recommendation which you made. That's not confidential.
Sir.
So that can be, if someone wants to see.
But records you also bring so that.
Yes, ma'am. We'll bring the records.
Adjourning the matter, we can clarify our own doubts.
There is some mention in the merit list due to pending of cases. Which cases we could not able to know. Only one case I could claim to know.
We have the list.
Case has been dismissed.
We have the list.
The
of cases.
case has been dismissed. Unless we know what is the case, they have mentioned serial number 10, case matter. Let them produce apprise us what is the case number so that we can get the order from the court whether that case is pending or it is disposed of.
Allowed
or what order has been passed.
Allowed dismiss.
Allowed dismissal.
We have the list, my lord. We have the list.
We will.
Kindly supply that list so that we will see next date.
We
can also verify, man.
See that information is available.
We will have. We will. We'll assist.
Case you can give him. These are the cases.
Cases, my lord. We'll give a list.
We'll have perfect case for the next.
Item number 3.
In that case, will compliance of lordship order was settled on the shoulder of my client mirror, and for your lordship kind appreciation with the short memo, we have complied with the order your lordship passed in the last occasion that in pursuance of your lordship order, the petitioner student was supposed to submit all of the original documents, whatever the documents with her, in the college on last 18th Miller. And after 18th Miller, we complied all of the documents. Your lordship may kindly appreciate. And on 23rd, by letter dated 22, that is an annex 2 of my memo, short memo. Since I have received that document in the late hour of yesterday night, Miller, page 6 Miller, on 22/11 Miller, we have made all of the documents and again the original documents on 25 Miller to registered post. I have submitted all of the documentation regarding thorough compliance of your lordship order dated 14/11 Miller. Order was passed on 14/11, but in the order sheet it has been mentioned on 13/11. That is because of that is a noting in the footnote of today's list. The college has the OP number 4 college in which the petitioner is prosecuting her first year study method. It was directed if the petitioner complied with my last order, last order in submitting the documents, whatever document you transmit to the university authority, then the university authority is supposed to take a decision regarding the inter-college transferability case of the petitioner. It is the now the thought of the university.
And for the university. And I just got that memo filed by my lawyer senior member. On 25, it has been sent a register, but it has not been registered. Okay. Those documents we have not received those documents. Once we get those documents, we'll put it before the medical board for consideration. Subject to matter if the
So how did you send it?
Millard, we send it through email on 23rd. Then on 25th and last Monday, I means this continuing week, Millard. Last 25th, we send it on registered post, all of the documents.
When did you send through email?
Email on 23rd, through affidavit, through memo, and I have already, your lordship may kindly appreciate page 8.
You have not received the email.
Instruction is to email.
So tell us at 2 p.m. whether you have received the email or not.
And when?
Original document is also very vital because of the.
Let us see, because he does not know anything. So let us see whether he has received the email or not. At 2 p.m. tell us.
You have sent to BPUT.
Yes, register before that.
Have you served a copy of this to him?
Well, just now because I prepared it.
Because there's a page 8, there's a copy of that email thing. You check.
Just got a copy. I'll verify it.
No, you can open it. Please refer to page 8.
Tell us at 2 p.m. whether they have received the email and the documents or not. When did you send the documents?
Original documents on 25th, email on through email on 23rd. This scan copy.
So first email, thereafter registered post.
Registered.
Okay.
Because Sunday, it was Sunday, the intervening time was Sunday.
Good. You have sent my email. That is on Saturday. Good.
Okay.
And this is there. You can check. Wanting documents also, you can check.
Item number 4. Item 4.
Yeah, you were supposed to get instructions, I think.
I have filed the counter affidavit, Miller,
When?
on 27.
Yes, it's there. It's there.
The prayer of the petitioner is he is seeking a direction to execute the lease deed, Miller. And under annexure 2, he is showing the similar orders were passed. On that ground, he was praying before your lordship that order will be passed for consideration of the representation. But my lord, the cases under annexure 12 and the case of the present petitioner is different, Miller.
No, what have you done?
My lord, in this, I have filed counter affidavit. Lordship will kindly see paragraph 8 of my counter affidavit. He has not deposited the royalty amount.
Oh.
And 1 year has elapsed in the
And
meanwhile.
1 year has elapsed in the meantime.
There is no representation on behalf of. When did you serve a copy?
On that day, Mr. on 27.
Sure.
Yes, ma'am.
All right. 27th was yesterday. So it's okay.
Counter affidavit has been filed on behalf of the state of Orissa, a copy of which has already been served upon Learned Counsel for the petitioner. That's all. The petitioner has filed present writ application So-called a counter affidavit has been filed. No, sir, वो तो लिखा दिया ना. Following was the order passed by us on last date 13/11, sorry, 13/11/2014. So it has been stated in the counter affidavit. Which paragraph?
Paragraph 8.
In paragraph 8 of the counter affidavit, that where is that?
The case of the present petitioner is not similar to the case covered under Annex 12.
No.
The case of the present petitioner is
Paragraph 4 also, that she did not come to execute the royalty.
paragraph 4 and paragraph 8.
Paragraph 4 and then paragraph. Paragraph 8, they are saying not similar to the other cases. Paragraph 4, they have stated what we have defaulted in doing, not doing that.
Where is that statement?
Last line, due to non-deposit of the royalty, etc.
Due to that, as the petitioner has not deposited the royalty amount, comma, the requisite royalty amount, comma, the agreement has not been executed. Does you understand?
Yes, ma'am.
Stop this matter on Monday. First 5 cases.
But write the 9, no?
Yes, ma'am.
Sorry.
So these facts were stated in this consider.
Relying on the entity order saying that similar matters have been encountered. So exactly the knowledge, we're trying to take advantage of similar matter in but not exactly consider. Maybe saying entity when case was there, that is why I did not deposit the royalty in our position. Maybe little hearing will be necessary.
Right. Item number 5.
File counter affidavit will not 2 weeks time more be granted to file the counter affidavit.
On last occasion, noted that if no counter is filed, if lordship will consider giving an interim order.
Yes, that was there, I think.
It's the same interim order at flag A of the lordship. A similar matter earlier.
Just let us see the last order.
Yes, sir. Last order is on 14/11.
Yes, paragraph 6.
Yes, sir.
Wait, let us go through the order. Why in such a hurry? 14/11/2024 order, last date. We had said that if no
We had said,
is filed, we will consider for passing the interim orders.
What interim order?
Whenever I have flag A of the lordships in my IA, I have filed a similar order which has been passed by the coordinate bench of this honorable court earlier in a similar matter.
The 25%?
No, but this is not 25%.
Okay.
Well, let me kindly have page, the last portion, page 8 of that flag A. May I read it out? Para 8, page 8.
The additional charge has been increased after execution of the lease.
Yes, sir. So the coordinate bench passed an order that you please execute.
No, we are granting for the 1 week time. File your affidavit.
The difficulty today is this way. I have already executed first year of lease. Now, after the first year, I am not entering the lease because they are not granting me the next year lease. Although originally it was for 5 years. The option was for 5 years, but lease is executed annually.
Now, my lord, 1 year lease, after 1 year lease, the second year lease, they asked me for an enhanced amount, which and similar matters. Now, my lord, the problem today is threefold. Number one, I am not able to enter my leasehold land. I am not able to lease. Now, my lord, state is not able to get revenue because until and unless I query, state will not. Now, my lord, there is rampant illegal mining happening.
State wants that.
Let that happen for 1 week more. We will decide it.
My lord,
Why have you
because
not
I have-
filed affidavit?
My lord.
Why? There was an indication that we shall be passing an interim order. So you want us to pass an interim order?
No, my lord. Only the inconvenience, perhaps, my lord. Some information is to be gathered, and therefore 1 week.
Have you received a response to your letter?
Response, I am
So
not.
then how are you presuming that some information there?
I will ask them to
Please bother.
turn up positively, and if they fail, your lordship will pass interim order.
Following order was passed. No, following order was passed by this court on such and such date, first date,
At least response to respond to your
requiring
letter
the
asking for
state
time.
to file an affidavit. So stop. Despite clear indication given in the order dated 14/11/2024, no counter affidavit has been filed. So stop. Learn AGA informs this court that he has not received any instructions. So stop.
When did you send the letter?
20th. Letter was issued on 20th.
So we passed the order on 14th, you issued the letter on 20th.
I drafted for.
Here it is, all right.
It's a circumstance, a chance of intentional non-filing of the counter affidavit by the concerned official to favor the petitioner cannot be ruled out. So stop. List this case on 1 week. So stop. In the meanwhile, counter affidavit must be filed upon payment of a sum of rupees 10,000 in the account of Social Welfare Fund. So stop. The government shall be at liberty to fix the responsibility on the concerned person for non-filing of the counter affidavit and recover the amount of cost by following procedure. 1 week? 1 week. Give me first 5 cases.
It's 5 to.
Just to lordships, just to convention of management, can you have annexure 2? Just for a moment.
No, mister, we are not doing anything. We wanted them to file a counter affidavit.
I completely.
They have not done, they have not filed.
To help me, they cannot.
No, that is a chance. They may say it's
I
incorrect.
completely got. I'm only saying it is their letter, annexure 2 and annexure 3, where it is their letter saying that you have been the H1 at this price. Let me kindly 3, annexure 3.
No,
page
that we
5.
understand. That will be decided on deciding on merits. That we will see. But see, we are passing an order specifically mentioning that we shall pass an interim order.
Had you indicated?
They are not doing it.
Yes, yes, very indicated.
My only thing is because similar orders have been passed, probably that they also know probably that similar orders.
No, but they have to mention that.
I
They have to
completely got
respond
it.
to the
I
letter.
completely got it.
Have you mentioned that interim orders will be passed on failure to file counter affidavit? Mr. Panda?
My lord. Yes, I have asked them to.
No, it's all right.
Download and see that.
Download, you have not mentioned in your letter.
Yes, I have mentioned.
But there is a miscommunication, my lord, with regard to the date. My lord.
Let us see, let us.
What date have you mentioned?
Next week, posted anterior to this date. My lord, posterior to this date.
Let us.
So that they explain or they'll explain whatever.
Item number 6.
6 madam, therefore, Mr. Das.
Why 1 week?
Because the Lordship last occasion directed from producing the document, certain document, he called for only 1 week time.
No, last time he said he wanted this time to get ready.
Yes.
Twice it was passed over. So we
Yes.
adjourned.
Yes.
Last time he said one adjournment, I want to get
With
ready.
regard to the selection procedure document,
No, I'm not concerned about the case. Remember the submissions.
and today he has some personal link only.
Let's see the order. This is the order impugned,
Order by law.
annexure 3.
Annexure 6 madam. Page 168.
Page 178, they are speaking relevant portion of the order. Correct.
Sorry.
Then Prema from next week because they are not there.
How much cost will you pay? Because it's the 4th time you are seeking adjournment. 10,000?
Only one. Only one time.
No. Will not do it.
Or Lordship call it next Monday or next month. Next Monday. Do
Make your submission.
Mentioning on his behalf, madam. I only play next Monday.
We are ready. We are ready to grant you adjournment. They are taking it too lightly. This is the 4th time when an adjournment is being sought on behalf of the appellant. So stop. By way of last indulgence, matter is adjourned to Monday. So stop. We make it clear that if any further adjournment is granted, that will be at the instance of the appellant, that will be subject to payment of cost of rupees 20,000.
Item 7.
Yeah. Which happy has been preferred against the judgment rendered by the Honorable Kenny Judge. Your Lordship will find at page 47 it starts.
Yes.
47, my lord, the impugned order. It starts from page 47. Relying on the judgment certified by the Honorable Court in the case of Subarna Dibya and Bhimsen Prusti, this writ application was disposed of. But we have filed the merit appeal because it cannot be held to be covered by the judgment rendered by this Honorable Court in the case of Subarna Dibya. Your Lordship may kind for a moment. If your Lordship comes to page 10, had quoted paragraph 19 of that judgment. It is available at page 10.
Yes.
May case that it would be evident from the interpretation of the judgment referred to supra vis-a-vis the existing rules that a retired primary school teacher who was surviving on the date on which 1986 rule came into force, irrespective of his date of retirement, will be entitled to receive pension prospectively and can be nomenclatured as a pensioner. Thus, a harmonious interpretation of the rules could lead to a conclusion that the family of a primary school teacher who had retired and expired prior to introduction of the pension scheme shall not be entitled to receive pension, not being the family of a pensioner. Here, in the case of the respondent, he expired in the year 1977. The rule expired in the year, by that time, neither the 86 rules nor the 2001 rules came into existence. So my submission is, his case cannot be covered up. That apart, my lord, that provision which has been taken note of, Rule 82B, that is quoted in page 6.
82B of
the 1981 rules. This is an amendment brought to the 81 rules in 1986. That amendment has not been challenged anywhere till date, man. That has been reflected in page 6.
Enter judgments.
what judgment?
Judgment Subodh there with my signature.
Which judgment?
Judgment of Subodh there which on signature related and they have also admitted in that kindly city order making. They admitted it is covered and this paragraph.
Admission will not do.
No, kindly city order. Kindly city paragraph. Kindly city para 18.
Please tell us how it is covered.
Para 18.
They say it is covered. Can it be covered?
Kindly city para 18. Para 18.
All right. When did you retire?
I was in service diet. In service death.
When did you retire?
I have died in service.
When?
77.
1977. In 1977, which rules were applicable?
By that time, previous rule was there, people benefit scheme. But para 18, they are also decided that
Yes.
those who are in service
died.
and that after the court of death, they are entitled, that has been kindly see para 18. That has been decided to control our appeals court. Those who are in service,
They would have retired.
This is something a process. This is something. Is this the reasoning that had you not died, you would have lived up to that date? Therefore, you are entitled.
Superannuation.
on superannuation, that are decided control our appeals court. That are also this.
We'll see.
Para 18 kindly. Para
18 of this?
Nice.
All right.
Yes.
May I develop?
Yes.
The only other question which needs to be answered is as to whether the family members of one who died in harness would be eligible to receive family pension or not. In such eventuality, the decision will differ from case to case. It is needless to say that in consonance with Orissa pension rules and other provisions, the family of an employee who died in harness would be entitled to pension or proportional pension as would be admissible taking into consideration the number of service rendered by him and other eventualities. Rule 8 of the ATC rules stipulates that an employee shall be eligible for pension, gratuity or death count and gratuity as the case may be in certain circumstances, one of the same being retired before superannuation or on medical ground or permanent incapacity for future service. If an employee is entitled to pension having retired prematurely on the being permanently incapacitated, there is no reason to extend the same benefit to employee, the benefit of the family.
Mr. Counsel, this order, this judgment is directly against you.
No.
This is the, please come. Please come in the middle. Slightly below the middle. If an employee is entitled to pension, having retired prematurely on being permanently incapacitated, there can be no reason to extend the benefit of family pension to an employee who dies in harness.
Yes, in such cases, the authority shall first decide as to whether the employee was eligible to receive proportional pension in consonance with the rule, and if it found that in fact the employee is entitled to receive pension, take a decision with regard to extending the benefit time.
Absolutely correct.
Yes, if he would have supervised service in usual course, but unfortunately died in harness.
Where?
Last line. If he would have been
just a minute.
Last line.
Receive proportionate pensions.
Proportionate pension, whatever should have discharge duty. That is no dispute. Only the minor director had been allowed to
Just a minute, let us understand. What submission you are making is impossible. Is impossible under law.
That has been because the rule says it is there is no rule provided.
Mr. Counsel, this is impossible that a person who dies in 1977 will be entitled for pension under a scheme which is implemented after his death.
Yes.
This is impossible.
Because I was in service, I had a harness. Had I been continued serving?
Had you did not continue. Had you continued in service, you would have received salary also.
Family pension, yes, family salary. But that is decided by the National Court and confirmed on Appeals Court. That part and many person has already given the benefits. Many person already given benefits pursuant to order of the National Court. The only case they have challenged in this case.
No, probably yes. Very different. Very clear, Mr. It doesn't support you.
Yes, that by virtue of this judgment, thousands of
might have been decided.
Benefits. This only case they have challenged, and that too, may kindly see the order. They absolutely cover.
We shall not follow what is incorrect.
That are this
says this is in view of 1996. Then we will. Yes, if any.
That is mentioned by page 49. SLP number 14265 and back.
Where is that order? This is a single bench judgment.
No, yes, they have gone down arbitration directly.
Where is that?
That they have mentioned in the judgment by currency order, page 49. In the order, they have mentioned the SLP number and page 49.
Where is that order?
That I'll collect tomorrow. Only one page order, the SLP dismissed. That is only, I'll produce.
Could you, there is,
Huh?
we will not present.
I'll produce on that order.
May present.
SLP order, I'll produce.
There is absolutely nothing. See, for the first time I am hearing this, that a rule which was not applicable on the death of a person, on the date of death of the person, or on the date of retirement, will become applicable, because had he continued in service, he would have remained there till
After the court of
Date
death.
of appointment or date of death?
I'll file them.
Appointment.
retirement.
Appointment or date of death?
I'll file them. Sometime. Two timing answer.
Your lordships are following this matter sometimes later.
So that SLP also, you get that order?
What I was submitting, my lord,
Yes.
if it is coming once again, let my learned friend take instruction on the page 6. I have quoted that provision, that amendment portion. My submission is, it has not been settled anywhere. That amendment says.
No, but why it has been done, allowed in so many cases? This is what he is submitting.
That is one of his grievances.
Sorry, ma'am.
That is one of his grievances.
Yes. That is, I can take that instruction as to identical cases as to whether it has been allowed or not. But the amendment which is reflected.
Law which you are saying is
The person who is originally entitled to family pension, he is not there. The family members will get.
Yes. That what is the amendment in.
as requested on behalf of the respondent, place this matter on 2 weeks.
Item number 9.
In the presence of the input ordering on the unlisted 1 will not see page 11 and 12, running page 11 and 12 manner. Kindly have a glance at 11 and input order will not see. There is a single way. So kind of
Connection?
annexure 1, page 11 will not see.
You are challenging? What is that?
That's a kind of clause of paragraph 4, madam. Paragraph 5. Since that the dispute is pending before the cooperative tribunal, but without any progress on account of absence of bail, the restrictions stand disposed with an interim protection as against annexure 3. Till such time, it is substituted by an order in IA number 16 of 2024 minor. Annexure 3 is the dismissal order minor. What happened in this case, minor? The private opposite party number 4 was suspended, and thereafter he was dismissed from service manner. And that dismissal order is under challenge before the in service dispute case number 3 by 2024 in cooperative tribunal manner. And so far as the IA number 16 of 2024, that was filed in dispute case number 2 of 2024, which is arising out of the suspension order manner. And the said IA was withdrawn by the opposite party number 4 before the tribunal. And that has been substituted in this order manner without hearing the appellant manner.
Yes, issue notice. Stay. Issue notice to respond number 1.
Opposite party number 4, your say.
Party number 4. Yes, 1 week, 6 weeks. Okay.
3 and 4, your say.
3 and 4.
3 and 4. All right.
Item 10.
The appellant challenge order of honorable single judge page 16 annexed 1 lordship. The relevant order is at page 18, paragraph 5 lordship. The writ application against a private finance company is not intended in view of ratio decided in Federal Bank Limited versus Sagar Thomas and others reported in 2003, Roman 3 CLR 801. However, since the petition is ready to and willing to pay 50% of the attorney fees, this court entertains the writ application, and it is directed that the vehicle of the respondent shall be release on payment of 50,000 money. This is an ex parte order passed by under single judge, my lord, and in violation of guideline issued by RBI, your lordship. If your lordship peruse the guideline,
Stay.
They don't usually buy, but they get some money. They will have a problem.
Yes.
Item 11.
The sole, one respondent, private respondent,
my lord,
that is all.
RBI also made party in the repetition for the which
To make it maintain.
he has nothing to say, but
All right, we'll issue notice only to respondent number 1.
yes, your lord.
Have you arrayed RBI as a party?
Absolutely, because
Yes.
repetition that I have
It is
to.
not necessary.
It is not required to issue notice.
Item 11.
May I please, my lord, the same appeal has been filed for restoration of this WPC, which was dismissed for non-prosecution. My lord, may kindly see annexure 1, the impugn order. At page 8.
So why you are not present?
What has happened that the council looking after this matter was elevated to the bench. And after that, the original petitioner died on 27/5/2021.
And counsel appearing on behalf of the
Not 1, 2 councils.
Commissioner. The case is made out for restoration of WPC number 12092 of 2012, which stood dismissed for default. First off, the order dated default by an order dated 22/8/2024. First off, the said order dated 22/10/8/2024 is hereby recalled. First off, let WPC number 12092 of 2012 be restored to its original file. List WPC number so and so for appropriate bench.
Item 12.
My lordship, am I audible,
Yes.
sir? My lordship, the senior counsel is on his legs in Supreme Court. I humbly request my lordship to adjourn this matter for Monday.
Madam, senior counsel?
Yes, sir. Yes, ma'am. He'll be there physically on Monday to argue the matter.
And requested on behalf of the petitioner, list this matter 1 week. Yes.
Item 13.
My lord, the petitioner have filed the PIL application.
Item number
13.
The petitioner have filed the PIL application because notices to protect the land of Sri Nilakanteshwar and Sri Venkateshwar Shiva Temple existing since the 12th century as the ancient and religious monuments, your lordship. That the property under annexure 1, my lord, lordship may see in page number 13, my lord, for annexure 1 stands recorded in the name of Nilakanteshwar Deva, Sri Venkateshwar Deva, the Shiva Temple, my lord, as the tenant, as the recorded tenant, my lord.
But you are saying that not to prevent obstacle in water flow?
My lord.
So that
My lord,
through the
land
temple water is flowing?
Yes, my lord. The status of the land is the Jalasoy, my lord, the water reservoir. And
thousands of pilgrims every year comes and take the holy bath, and not only for the religious purpose, my lord, the area peoples, the local people also use the water, my lord, for the agricultural purpose, my lord. So, my lord, by manipulation, my lord, another in the self-same land, my lord, another ROR has been prepared by the Tahsildar in page number 16, my lord, where the opposite party number 4 and 5, the father of the opposite party number 4 and 5 have been shown as recorded tenants. So, the opposite party, private opposite party 4 and 5 trying to fill up the land and to make the construction thereon. My lord, in many approach, the local people have made many approach to the local administration, my lord, under annexure 4, my lord, even under annexure 5, my lord, a representation has been given, but it is observed by the local administration inviting the reference to the letter subject cited above. I am to send here with a copy of the grievance petition by the villagers of Chaurapada regarding the unauthorized construction of the market complex on the land of Sri Nilakantheswar and Uttaraswar Mahadev in Mauja, Chaurapada, and to request you to look into the matter and take necessary action, my lord. Till yet, my lord, the district administration has not taken any action, my lord.
However, in the meantime, the opposite party have filled the water logging area for purpose of soap. Construction for purpose of soap.
So, for the purpose of soap and market complex, yours.
What is soap?
So, market complex.
Oh.
Yes, you should have some grievance redressal forum. Like for all these things, the people straightway come to the High Court. So you should have it. The present rate application filed in the nature of public interest litigation, the petitioner has alleged what is Annexure 3?
My lord, Annexure 3 is the impugned ROR. Annexure 3, my lord, the local people were redressed before the executive magistrate, my lord. My lord.
Local people had approached.
My lord.
And who are they? The private parties, Santosh Behra and Ghanshyam Behra?
My lord, private parties are opposite party number 4 and 5, my lord.
This is a private dispute. So what are they doing?
My lord, they are doing actually having had in clothes with the local Tahsildar, my lord. They are making the construction, my lord.
So that ROR change correction must have been pursuant to some order passed in the proceeding. No, cannot be suo moto. I hope you are not parties in that application.
There is two consistent ROR, my lord. One ROR stands recorded in the name of the Sri Nilakantheswar Mahadev, and another ROR has been stands recorded in the name of the private party, my lord.
Second one is the subsequent ROR. There has been some correction, I think. But those originally DP cannot sell also. Unless they've done something and market does, they say they get it recorded as a private name. It is meant for benefit of the DP. So you have no private interest other than water flowing from the land.
My lord, there is some religious sentiments is there, and because the
If you find there is some private dispute between you, we may deposit.
no, my lord, it is not. It is purely a public interest.
And why are you mentioning these dates? You said you submitted representation in 2023 and the Tahsildar took action in 2022.
My lord,
Is it deliberate or a mistake?
My lord, since
No, please.
That is not deliberate. That is
What is
deliberate.
happening there?
See, this is,
Please, sir.
no, that is 2012, 2023.
Yes.
The Endowment Commission is not a party. It is temple land.
We can add. See, paragraph 10 is we submitted
File your affidavit, we will say.
representation.
That is fine.
Yes, yes.
8 weeks.
We file counteractive.
Item 14.
Carefully examine your petition. There may be some typographical errors. Please check.
Please, my lord.
Petitioner before the Lordship, President of the Consumer Forum, he is seeking pay parity in terms of the state consumer protection rules. The Consumer Protection Act,
Why has this come before the division bench? Yeah, tell it validity. Huh?
The rules, state rules are not in tandem with the model rules by the central government.
So declare those rules. Challenge those rules.
To that extent. The salary part to that extent. Only to that limited extent. Even as per the second prayer, without getting into the first prayer, in the second prayer.
Who are you?
I am the president of the Consumer Forum.
For which district?
Bhadra.
Do you accept the appointment for the challenge?
I'm sorry. Clearly it says that it should be as per the latest super time scale, 50% of the initial super time scale pay of the district judge. So what I am being paid.
So that violates this provision of law.
The provision is this that state consumer protection Orissa 4.2 rule 4.2 the salary of the president and members of the district commission.
So this is a rule. This violates which provision of law? This rule is contrary to which provision of law?
Model rules.
Model rules.
Model.
Mr. How can you make this submission? A rule can be contrary to statutory provision. The rule can be contrary to constitutional provision and therefore bad.
I understand.
How can you make this submission?
I'm only
all right. No question of relying. The question is of whether you can refer to that model rules, whether they have any statutory force.
They have a statutory force under section. That's my understanding. I may be subject to what your lordship says.
So, don't make this submission. Please.
Section 102 of the Consumer Protection Act. Actually, kindly have a look at section 102 of the Consumer Protection Act. Power of the state government to make rules. The lordship got that?
Yes.
The state governments may, by notification, make rules for carrying out the provisions of this act, provided that the central government may frame model rules in respect of all or any of the matters with respect to which the state government may make rules under this section.
Please, you don't make these submissions.
Yes, sir.
Just see, that power is vested with the state government. The central government can just frame rules.
No.
Finally, it is for the state government to.
There is a, why I was making it, there's a stipulation that as possible, the state government, while making any such rules, so far as practicable, they shall conform to such modern rules. There is a may there. There is a may there, of course, my lords. There's a may there. And my lords, even if I give I give up that prayer. Second prayer, my lords, at least I should be given at par with the recent district judge my lords initial superintendent scale.
So when did you join?
I joined in 22.
And when were the rules
March
framed?
2022. Annexure 2, my lords. Annexure 2 at page, my lords, page 21.
21/3/2022.
21/3/2022.
So for that, the matter will go before the appropriate bench.
No.
Learned senior counsel appearing on behalf of the petitioner has submitted that the petitioner will not press the prayer for declaring rule bracketed 4(2) of Odisha Consumer Protection so and so rules 2022 ultravirus. Stop. So accordingly, let the since the writ petition does not anymore involve question of validity of any statutory provision, let the matter be listed before appropriate bench according to roster. Yes.
Right.
Item number 15.
Item number 15, I have instruction to appear in this brief, in this case, as the brief has been transferred today. I'll be filing my butler today.
So when was it brief transferred?
After mentioning the matter.
Yesterday, March.
Yesterday, after the mention was accepted. What is your name?
Subhankar Rao.
Mr. Subhankar Rao and counsel states that now he has been instructed to appear on behalf of the petitioner. You have filed Wakalatnama?
I'll be filing in course of the day.
And shall be filing fresh Wakalatnama in course of the day. Full stop. He seeks adjournment for the said purpose. Stop. The matter has been listed on mention having been made for urgent listing. Stop. List this matter 8 weeks as there is no urgency.
Similar matter, Your Lordship.
What is happening?
Can you just not appear on behalf of the petitioner and make a submission? I think that petitioner wants to appear in some examination.
Your Lordship, the similar matter, on the similar issue, the same matter has been posted to 2nd of December, Your Lordship.
Instead of saying that, what is this file transferred and all this?
Your Lordship, I just pointing out after.
Because it is listed on
Practice,
mention.
we are not happy with this practice. That a mention is made, mention is accepted, the case is listed, lawyer is transferred. What is this? The case is transferred, lawyer is changed.
What is that number?
WPC 18543 of 2024.
18543
of 2024.
Very bad. This is practice.
Appear on behalf of other counsel.
This is matter on. So along with.
It is stated to be a similar matter.
The matter is same.
Your Lordship.
Mr. Rautra has submitted that similar matter has been adjourned to
2nd of December, Your Lordship. 2nd of December 2024. Monday.
What that is what? That is regarding what? You are appearing for whom?
On behalf of staff, for DME.
Yes. So what is this matter about?
In this case, this petitioner claims that she has taken admission in the year 2023-24 without appearing the entrance test. Your lordship has decided that matter in judgment.
No, she's saying that similar matter is 18543 of 2024.
That is also same. Similar in that they are also claiming regularization.
2/12/2024, 18543.
Item 16.
Lordship, the petitioner is challenging the tender notification dated 17/5/2024. That is at page 13, annexure 1. Page 13 on annexure 1, your lordship.
You are challenging.
Yes, your lordship. What happened in this case, your lordship? In this tender, your lordship, they have awarded in two L1.
What is annexure 1?
Yes. Your lordship, kindly have a glance, page 119.
Mr. Counsel, you are challenging which order? Which you are challenging what?
That is tender notification, your lordship.
Tender
Because
notification.
of what is the illegalities and what is the manipulated in this tender, you lordship kindly have a glance at page 119.
What is annexure 1?
That is tender
119 part of annexure.
Oh, because page 13 is declaration of site visit.
Thereafter, your lordship on notification is there, your lordship. That is at page, your lordship, 24. That is running page 24. That tender notification.
But this
Your
is
lordship can have a glance at page 119.
Yes.
They have awarded two L1 bidders, your lordship. That is a violation of the tender and as well as the natural of justice, your lordship. Your lordship kindly have a glance, page 119.
Yes, we are there.
Yes, your lordship. That is your lordship serial number 1 in a similar price, your lordship. That is
but you have not given the complete tender documents. Page 1 and 10 you have not
No,
given.
both of them must have been given. Because both of them were L1 and therefore half to one and half to other. What is wrong in it?
Wrong because of your lordship. For a moment, your lordship, the petitioner is claiming that there is some manipulation because of that is a GEM portal by the authority, your lordship. What happened in this case, your lordship? For a moment, your lordship kindly see there is some BOQ, your lordship. That is bill of quantities, your lordship. So that should not be similar to both the L1 bidders. For a moment, your lordship, kindly turn to page, your lordship, 127. The present petitioner's bill of quantity. So must be, your lordship, different in both the bidders, your lordship. So there are, when the bid was open, your lordship, immediately the petitioner approached before the authority, your lordship.
So whether you are L1,
I am just L2, your lordship.
Then what right do you have?
Because of what happened in this case, your lordship, how can the similar price will be
that you will have to file. For that you will have to file a suit. That declaration you can get in a suit.
No,
Not here.
Two in one tender, the two bidders should not be worked, your lordship.
No, that can be done. See, if there are more than one bidder, the bidders found to have been declared L1, then the work can be awarded half to one and half to the other. What is the difficulty?
That may be, your lordship, but my
Other
prayer before your lordship.
How are you prejudiced?
You may not get it.
My prayer before your lordship, that BOQ, that is a bill of quantities. How can that is similar in two bidders, your lordship?
What is bill of quantity?
That's why that is, your lordship, at page 127.
What is bill of quantity?
bill of quantity as per the notification of the tender.
The bill of quantity is one.
Yes.
It will depend whether what was the quotation.
Yes.
So, bill of quantity, why are you referring to bill of quantity?
Because of your lordship, for a moment, prior to the bidding of the tender, your lordship, the authority conducted the meeting, your lordship. For a moment, your lordship, kindly have a glance. Page 123, your lordship.
So you are going to provide guard and in charge watch and ward.
And thereafter, the fuel is there, your lordship. Fuel may be, your lordship, that should not be differential amount. But in the guard and other charges may be different. Your lordship, for a moment, kindly turn to page, your lordship, 123, your lordship. Under annexure 6, your lordship.
Manipulation, see, we cannot enter into these things. Manipulation, you'll have to prove.
May I pray, your lordship, because of on 10/7/2024, there was one meeting before the authority, your lordship, and it was brought to the attention that the price quoted by the L1 bidders on the GEM portal do not align with the bill of quantities, that is BOQ, as they have not included the fuel cost. The L1 bidders, they have admitted that they have not submitted the BOQ, your lordship.
Why are you again saying BOQ? BOQ is something else.
That BOQ is
Maybe question of submission of.
So there is just manipulation, your lordship.
Manipulation, you will have to prove if there is something in your mind.
I have written to the authority, your lordship. Thereafter, they have replied, your lordship, and thereafter they have remained silent, your lordship, regarding this, your lordship.
It's like
my lordship, because of me.
No.
Then
Lordship, before the opening of the tender,
yes,
they have conducted, your lordship, the meeting.
yes.
And on that meeting, they have admitted that we have not submitted that BOQ, and they have not mentioned the fuel. So
mentioned
the fuel amount, your lordship.
They or we
Fuel
or
price.
the opposite party has not mentioned the fuel component.
No, that L1 bidders.
L1 bidders
Both
have
the-
not, which includes you also.
No, I have annexed, your lordship. The
others
present
one.
petitioner submitted the BOQ
Okay.
properly.
So that is there in annexure, that annexure 1 that is there.
Yes, your lordship.
Where
That is
so-
mandatory, your lordship.
No, where is it mentioned that they have not mentioned the fuel component?
Yes,
It is apparent from page,
your lordship. Your lordship, page 6, your lordship.
page 6,
Yes, your lordship.
not a government. It has to be a
Paragraph
document.
5. Paragraph 5, your lord.
Paragraph 5
Running,
is your government.
running page 6, your lordship.
Paragraph 5 is your government. So where is the document?
Document is, your lordship. I have annexed the petitioner's document, which was submitted by the petitioner. That is the BOQ, your lordship. And your lordship, the under annexure, your lordship, 2 series, sorry, your lordship, the 3. The mine price for your lordship, the same price cannot be, because of this is a website GEM portal. your
Come
lordship.
to
That is
11.0 at page 22.
Yes. Yes.
Go there.
So my prayer before you lordship.
See, what you are alleging, Mr. Counsel, cannot be decided in writ jurisdiction. And the remedy is there, 11.0. You can avail that.
No, your lordship, because of
Otherwise, that is it. You will be required to lead evidence.
your lordship,
Because
may I pray your lordship can take it next week. I will submit some judgment.
what judgment?
Because of the two similar price cannot that because of your lordship, that is a website portal, your lordship. So this is the
Don't
similar.
show us judgments, convince us what you are saying. We are not satisfied what you are saying. We are not, what you think is, can't the same court can't be there.
May I pray your lordship?
GA is supposed to be sort of thing. Some manipulation is going on. Let that land go.
May I pray your lordship? Notice may be issue a lot.
No, sorry.
Your lordship,
Sorry, unnecessary.
your lordship kindly, I pray your lordship kindly taken next week. I will submit some judgment, your lordship.
All right.
Because
we will permit you.
similar two price cannot be. Your lordship. The two similar price should not be in website portal, your lordship. Exactly similar price, your lordship.
Should not be or cannot be? Should not be.
Now, suppose there are two parties, and if they decide to quote 4% less than the price of the work, then the amount will be same. And this is how the parties quote. It is not that there is difference of 1 rupee or something.
Because of that, your lordship, I have lost. Your lordship submit the.
Why don't you file a suit?
Complaint
You can win
before
there.
the authority, your lordship. I pray your lordship kindly taken next week.
Sorry.
I
We
will
will
place your
adjourn.
lordship some judgment.
We will adjourn subject to, if you agree, we will adjourn, you will have to pay some money. If you succeed, that money will be returned. You are ready to?
Your lordship can call Monday, your lordship.
Monday, as requested on behalf of the petitioner, this case on Monday. So we are not satisfied with the submission advanced on behalf of the petitioner. We have heard him at length. Land Counsel, however, submits that he shall produce certain judgments of Supreme Court in support of his submission that two bidders cannot tender bid of same value. So stop. Next. We make it clear that if on the next date we are not satisfied with the submissions advanced on behalf of the petitioner, if on the next day the Land Counsel for the petitioner is not able to satisfy with that the judgments which he intends to rely do not support his case, a cost of rupees 20,000 shall be imposed on the petitioner for wasting court's time. Yes.
Item 17.
In item 17, my lord, the prayer is for disposal of the mining appeal they have filed. I have got instruction that in the meantime, appeal is transferred to the district mining officer both. That's in the 1 week time, I have got instruction whether it is pending.
The periodic transport is appeals in the year 2021. By that time, old rule was prevailed. And accordingly, appeal was put out for the sub-collector. Now, the transport. The last order was passed as per his affidavit. The last order was passed on 19/8/21, page 47. The case is posted to 16/9/21 for hearing. No
or settlement. This is not further possible. And in the meantime, now they are going to execute the lease deed.
Sir, appeal has been transferred. What did you say?
Case record is already transmitted to district.
Because there was an order, if instructions are not received, he will be physically present in court. So what was the instructions on?
Instruction is
2910, you had been asked to say whether the appeal has been disposed of or not.
we have filed affidavit here on 25/11/2024.
So when was the order passed by the original authority?
This court.
Original authority when you have preferred an appeal
Yes, ma'am.
against which order?
Well, against selection of the annexure 2
Against an order passed by whom?
passed by the Tahsildar.
Tahsildar. Where is that?
That order annexure 2, page 25.
Annexure 2, page
25.
Date?
Um, 12/2/2021.
12/2/2021.
Thereafter, I filed a REIT application before this or no.
Just a minute. Now the power has been conferred. You preferred appeal before whom?
Before sub-collector. And sub-collector was the competent authority.
Just a minute. When?
On 2/6/21. By virtue of the order of this or no quoted.
All right. So when the rules were amended?
So amended at 23, like that.
When were the rules amended?
23.
23. Date? So the appellate authority who had the jurisdiction to pass an order under the previous rule will have to pass an order. How can you transfer the case? Is there any provision for transfer of cases under the rules?
Yes.
And since the appeal is pending since 2021. And in 2024 you are trying to transfer.
It is transferred on 30/10/2023. They have given a letter here. And what happens here, the Tahsildar sub-collector also writes, in between the lower court record also transmitted to the Tahsildar. So I have to take instruction whether it is pending or at least disposed of.
Pass order it to me.
In the meantime, they are going to execute the
Yes.
Item 17.
Just a minute. Which is the?
My looks I'm suffering from
All right. What do you want?
item number 8.
If you have some eye infection, then you must leave the court immediately.
Not conjunctivitis. It's not conjunctivitis. It's a bleeding in the eye, my lord.
All right, please. What do you want?
Next week, we will.
Which case?
Item 8 actually, that has been fixed for 2 p.m.
All right.
I'm okay with that. You're assuming call it on third?
Whenever.
Third, you're assuming.
Jointly requested.
Sir, bleeding in the eye.
Yes. Why have you come?
That may require that laser surgery.
And why have you come to court then?
Well, I raised some objection maybe I made.
No.
As undertaken, we are giving the written note, my lord, that will be taken on record.
Do it.
Who cases that?
Item number 42. My lord, videos are there. My lord, when your lordship had fixed up a time for hearing of the pilot, today the matter is there in the list, but cannot reach my lord the court.
Marriage.
Reach out. If it doesn't reach Lordship, we will fix up it.
We'll see.
Item 51, I had a similar prayer as my legislator.
Let us see.
Wait.
17, sir.
Developing sub-collector was directed to furnish information whether appeal was disposed of or pending. Here the Tahsildar filed affidavit. In the affidavit, he has stated that appeal is disposed of, and the last order was passed on 19/8/21. I have a glass to the 19/8/21. In the order dated 19/8/21, that is page 40, starts from page 47 and last ends 48. Page 48, case is posted to 16/9/21 for hearing, put up on 16/9/21. The case was not posted and thereafter no order is maintained, case was not posted thereafter. And he stated that case is disposed of by the order dated 9/8/21. Page 48 of my application. Case is posted to 16/9/21 for hearing. No hearing was done till today.
The petitioner has preferred this writ application with a direction to the sub-collector board to hear and dispose of RMA bracketed lease number 4/2021 file under Rule 46 of OMMC Rules 2016. Stop. The said appeal was preferred by the petitioner against an order passed by Tahsildar. Which place?
Both.
Both. On 12/2/2021. So stop. Let the sub-collector board be personally present in court on Monday at 10:30 a.m. Make a mention.
One matter.
Matter on special mention, WPC number 26066 of 2020.
The lawsuit on 13/11/2024 addressed the state government to file counter with the
Draft is actually ready. It has gone for signing. One more piece and it will be filed.
You'll also kindly have a glance to the IA.
Just a minute.
He's praying for 1 week time.
But the date has been fixed to today. That's why I filed an application. That is 15913 of 2020.
Just a minute.
Type B there.
এটা আছে পরা সেখানে ওপেন করে দিও
Yes. Yes.
What is going to happen today?
Yeah, you'll also kindly have a glance to page 9 of the IA. And
I have,
chapter 10.
I not seen the copy of the IA.
Okay.
So you have not served.
I already served.
When?
On I filed the application.
Filed it day before yesterday.
Yeah, 26. On that,
What is this IA?
IA will also kindly have a glance to page 8, annexure 10. On 20/11/2024, after lordship directed this then to file the counter, that already you also can have next page 9. The technical way has already been opened and the date is posted to today for opening of the financial view. Once it will be open, then I have to make all the bidders to party and it will linger.
No. Is there any bar or anything that only 10% will be selected?
But again, I have to make them all the successful.
So why? Because even if they are selected, you can also be selected if you fulfill the criteria. It is not that unless.
Because I am challenged the RFP on the technical ground. On the last occasion,
you understand what I am saying?
My lord.
Yes.
But since I challenge the entire RFP, once the entire RFP will go, then it will amount to again.
We will see later.
Why is it challenging the RFP?
You will also kindly have a glance.
No, not glance. You tell us.
My lord, or because they have not followed the guidelines. On the last occasion, your lordship inquired from me whether there is whether the guidelines are in respect to the space or in respect to
Already they are granting a time. It's not that urgent. 1 week time is allowed for. Further time is allowed for the estate to file it. 1 week.
Till gathered the process.
You are participating, no?
And I have been rejected. My application has been rejected.
All right.
So that's final.
It goes
Till
without saying
that day, they may be
that any action taken pursuant to the tender notice in question shall be subject to final adjudication of the present case. Yes.
Item number 3, before launch session, you are pleased to direct the BPUD counter to obtain the specific instruction whether the material through from our institution to become a portion or whether it was reached at their level or not. Now,
We have received the mail after the last order. After the last order, we had issued a notice on 1911 to the college. On 23, they have mailed us. And also today only they have replied to the mail, the letter I have provided my lord. In that letter, they have given that the college is not providing the NOC. The issue doesn't lie with the university. The university only grants approval. After receiving the NOC from the colleges that the petitioner seeks to transfer and the existing college. The existing college is not granting the NOC. Only after the document is received by us in all aspects, we'll forward that to the medical board member.
You are not granting.
You are saying is it received?
Your lordship may kindly appreciate page 6 of my memo. No, you just allow me if you are countering something. You just allow me to satisfy the honorable board. So that kindly come to arrange page 6 of my memo. Remember, whatever the documents
Whether you have granted NOC or not.
Yes, Millard, we have some. Your lordship may kindly record mine because I have obtained.
We will not record your. You do you have recognition by you? Your recognition is by the university.
Yes, Millard.
That will be cancelled.
No, Millard, we have
by our judicial order.
Millard,
if this is your conduct, then your affiliations have been cancelled.
Yes, Millard. Millard, that is 30.
Show us where is the NOC.
Not yet come. So how did you grant? Today is 28. So how did you grant on 30th 11th?
23/11.
Mr. Counsel, show us one document by which NOC was granted.
Millard.
Where is it?
Millard, that you may kindly appreciate page 6.
Page 6. Okay.
Page 6. I'm just ready. Millard, to the register. Have your lordship got it? Page 6 of today's memo. After passing of your lordship order of last 14th Millard, we were directed to produce all of the document whatever would be submitted by the students concerned to the university.
Mr. Counsel, we are putting again the same question. Whether you have granted NOC or not. Where is that all letter?
That is 23/11/2024.
Whether NOC is mentioned.
Millard, yes, Millard.
Yes. It is submission of all documents. It's a cover letter for all the documents that were submitted by the petitioner.
Your lordship may kindly see the list, Millard. Your lordship kindly. I have already submitted the list 4 and 5.
All right. List this case on tomorrow. When learned counsel appearing on behalf of the Synergy Institute of Engineering and Technology, Dhenkanal, has submitted
Miller.
that an NOC has already been issued
Miller.
by the college for the petitioner's transfer to SIET to GITA Bhubaneswar. First off, we have not been able to find out any document on record to indicate that such NOC has been granted. First off, learned counsel appearing on behalf of Biju Patnaik University of Technology submits that the university has not received any NOC. First off, list this matter tomorrow or Monday when the principal / director of Synergy Institute of Engineering and Technology shall be required to be personally present in court with the NOC, which according to learned counsel for Synergy so and so was issued.
May I only?
Has already been issued.
2nd December because college is 60 kilometers away from here.
Therefore, Monday.
Monday.
So that we can go.
Yes.
Also convey your leadership.
Full stop. If we find that so far NOC was not issued, we will direct for an inquiry into the conduct of this such kind of institutes.
What we have mentioned, you will
that you will see.
The letter,
The
letter we have mentioned that we have given the NOC.
That is already given, no problem.
We have already sent all of the documents on 25th. That is on registered board.
It is all right. If you have given, you just have to produce that.
You are not making one statement. You are saying every document, but you are not saying that you have granted NOC.
That is also obliged. Of that day,
We will direct for action against your institute.
Item number 18.
Too much. This student is unnecessarily has been dragged.
No, I was also very much conscious because I know the other part by this other that is to be implemented in the letter and spirit. On the very day of leaving from this honorable court, I intimated the principal to obey the order.
So he will face the consequences also.
18.
Who is the disciplinary authority? Can you take any action against the principal?
I'll take instructions. I'll intimate you.
Just let us know.
May I please? My lord, pursuant to your lordship direction, we have filed the counter affidavit yesterday and we are serving copy of the said counter affidavit in the court today.
Counsel for the state has filed, states that a counter affidavit has been filed. A copy of the counter affidavit has been served on learned counsel for the petitioner today in the court. Learned counsel for the petitioner seeks adjournment to consider the said counter affidavit and file a reply if so required. Yes, how much? 4 weeks.
Item 19.
4 weeks.
4 weeks. Item number 19. Sir.
In my lord, the petitioner is a contractor. In the pro tender, my lord have a glance to page 10 of Annex 1, running page 10. Running page 10, number 1, that is item number 2. Items. Item number 2 has been allotted to the present petitioner. And after verifying the spot, due to public agitation, the present petitioner is unable to work out the sale for which Annexure 2 is the confirmation letter directed the petitioner to
challenging the order of blacklisting.
Without assigning any reason and without prior notice and opportunity of being heard, my license has been blacklisted, that is Annexure 6.
For 5 year affidavit.
3 years. Annexure
weeks
6.
time.
I have filed to stay the Annexure 6, otherwise I will not able to work.
We don't know whether so-called notice was given to you or not.
No, my lord, as for
This is your instruction.
my lord.
They may file affidavit that so-called notice was given. 4 weeks.
Item 20.
Actually, adjournment matter to file some documents.
Why?
The latest policy of 24-25 manner.
Huh?
Latest policy of the government of Odisha. So the Kharif is related.
Why did you make a mention for urgent hearing, urgent listing?
Recently that policy has been come out because the
After you file the memo, after you file the mention slip, they have come out with some policy.
Yes, letter on that.
After you file the mention memo.
Yes,
When did you file the mention memo? When did you file the mention slip?
Yesterday or day before, you were making a mention, I think.
Like today morning, there's another man.
Another matter.
Another man.
No, Rabi crop, wheat crop, I
Yes,
remember you
that is
making.
also that is a
Yesterday you mentioned or yesterday?
today morning. Today morning I was in about but this the public interest litigation matter. Here the government is procuring 30 quintals of paddy from each farmer's matter. But the yielding of the lands has been gone off matter, and they are generally
Memo would have scanned
generally 20 to 30 quintals are being produced in per acre land. So that is the crux of the matter. And previously there is an order from the Supreme Court matter. There is annexure 1 matter. So the collector Balangir, to consider the representation of the plaintiff petitioner, let me read out the last para of page number 16 matter, where the collector has mentioned.
And before filing this writ petition, did you approach them?
Yes, ma'am.
Where?
Well, to the collector, ma'am.
When? Where is that?
Well, that is the annexure 2 matter.
Annexure 2 is the order.
Page number 16 matter. This is the order of the collector Balangir matter.
Representation.
Did
you approach the authorities before filing this public interest litigation?
Yes, ma'am. To the collector Balangir.
Where is that?
Then after I moved before this honorable court.
Where is that?
That is not with this person.
There is a government here also.
The previous public litigation.
Before filing the present writ petition in the nature of public interest litigation, the petitioner does not appear to have approached appropriate authority requisite under the rules of PIL Jubi. Stop this application is accordingly.
That has been approached. Then after moved before.
Item 21.
Legioners. So the order dated 21st November, the copy has been sought to the counsel usually appears from the opposite party institute.
Yes.
Here is the case, my lord. The petitioner state to a lordship come to page 19 annexure 4.
Yes.
After successful completion of the exam, the petitioner was provisionally selected for the admission taken in the BSc nursing. Petitioner belongs to the SC category. The bottom of that the SC category, she has secured 35 ranks. General 515 rank.
515?
Rank in general 515. SC category 35. Under annexure 5 page 20, the seat allotment intimation was given by the opposite party institute. There it was mentioned that for depositing of fees by 30th July 2024. After getting that information, the petitioner deposited the requisite fees on the annexure 6 page 21 on 27/7/2024. But still then the petitioner is not giving an admission. That's why the notice was issued for the institution.
Yes.
I'm appearing for this opposite party one and
But, to my instruction, the petitioner doesn't satisfy the minimum eligibility. But if you look at the mark sheet submitted by the petitioner,
Yes.
kindly see page 40. He is required to have 45% mark in chemistry, biology, and physics together.
Yes.
Chemistry, physics, and biology. The Lordship could see chemistry. She has secured together practical and theory 51. Practical and theory chemistry out of 100, she has secured 51. Then
Physics.
biology, she has secured 50. Then physics, she has secured theory 3 marks, practical 29 marks. Total coming to 32. In the mark sheet, it is indicated to be passed, but the percentage, if you are not, if it is taken to calculation, it comes to 44.33% out of 300. Now, our eligibility criteria, if Lordship would permit me to show, though I can file it by affidavit, but our eligibility criteria is this one. Para 3.4. Can I show it? I have only one copy. My notes will kindly affidavit.
Then you can refund the amount.
I will refund it. That's my instruction. Para 3.3, I have given a 3.4, I have given a pension mark. Only one copy I am having.
It's very clear, sir. You don't have. You take back you can take back your money.
Let that figure, I will take instruction only to 1 day after.
What instruction do you? As you wish.
Only for consultation is meant. Client.
It is the petitioner's grievance that she belongs to SC category, and based on her merit position, he was selected for admission into BSc nursing course in Kalinga Institute of Industrial Technology.
Yes.
Bracketed KEET. So stop. As was required, she had deposited the institutional fee, counseling registration fee.
It says.
They may not return that.
No, that is the admission fees that it shows.
75,000 rupees she had deposited.
Deposit, admission, so far.
Refund entire amount, sir.
I'll refund.
He had deposited sum of 75,000. So stop. Despite that, admission is not being given to her. So stop. Next, learn senior counsel appearing on behalf of KEET has drawn our attention to clause 3.4 of what is this?
Eligibility criteria.
Of the eligibility criteria for admission to BSc nursing course, which requires that candidate must have passed qualifying 12th standard examination and must have obtained a minimum of 45% marks in physics, chemistry, and biology taken together. First off, the petitioner has not scored 45% of marks. Stop. Next, learned counsel appearing on behalf of the petitioner seeks adjournment to obtain instruction from the petitioner. This matter on Monday.
Monday.
Let it copy be subs.
What copy? You can give us.
Item 22.
Last petition, your lordship granted 1 week time to obtain instruction. I have received no instruction. Lordship, they grant one more time, 1 more week.
Before he seeks any further time,
May I just bring to your lordship's notice the which I put to the lordship and your lordship thought that they should be given in the document. The lordship may kindly take page 52. Page 52 is the last supply that I had. And that has dried out.
52 is which annexure?
52 is annexure, P. 52 is annex P, part of P1. Last page of P1.
Yes.
This will show that my last supply has dried out on 30th of September 2024. And that is exactly the reason this invoice is dated the 20th of June 2024. And hence, immediately thereafter, I had made an application which is at page 33. Page 33, I had made an application wherein I had invoked their own policy. And if your lordship takes page 36, my requirement from the 1st of October was at least 30,000 metric tons, my lords. And my lords, if your lordship now takes page 19.
What is there in page 36?
Page 36, my lords, my requirement, column number 9, 30,000 metric tons.
Column number 9.
Serial number 9. Requirement of iron ore under this scheme. And this application is in terms of their scheme only.
No, that is not your requirement is 5217.
So that is the month. That is the monthly requirement.
Yes.
This application is for the quarter. If your lordship sees at page 35 at the top, application form for allotment of iron ore to the standalone industry within the state for the quarter.
Your total requirement is 30,000 MT.
Yes, madam.
You don't have any captive mine.
I don't have a captive.
Then
my supplies have dried out.
All right. No. Then 30,000 is this amount is to be deducted from 30,000. Less quantity under LTL. So you are having something under LTL also. 14,000.
Very small quantity. That is there 14,350.
No, this is not small quantity. This is
yes,
half.
Yes, madam.
This is about half. So you are entitled to 5,216, like 15,000 something for this quarter.
Yes, madam. Yes.
July to September.
Yes. July to September.
It's not that you are entitled.
No, that my lord is borne out from page 19, madam. Kindly see page 19.
Page
19. There I have given a table, my lords. Because of the deficiency in supply, because supply is tapering off, your lordship sees the production is going down and it is now in the deficit. 1,000 livelihoods.
No, 19, page number 19 of your repetition.
Yes, ma'am.
Yes.
I have given a table, my lords. And your lordship sees the present production, there is a deficit, minus 4,337.
Yes. Why the officers are not responding?
1 week or at least.
No, we will take up the matter every time.
Sometimes we have to take instructions over telephone. Letters the officer.
No, every day. Monday, Tuesday, Wednesday. Let us see.
Please tell us.
See, it's a very simple thing.
Sent. When has the letter been issued?
I drafted it on 21st.
When has it been issued?
27.
So they have issued it yesterday.
Very difficult. You can't do.
Well, Monday you'll also fix.
Monday, okay, we will take up the matter and we will take up the matter every day.
No, not every day.
It's such a simple. Are we required to adjudicate upon such things?
No, my lord. I am sorry, extremely sorry, my lord. Today 28.
On Monday, my lord, I will positively.
All right.
But that's something seriously wrong. The order has been passed on 21st. The letter is sent on 27th.
I have.
And if we had not asked that, we would have asked the officer to be present here
My lord, I have
for not responding.
drafted it on, but something because of the.
Despite the court's order dated 21/11/2024, no counter affidavit has been filed. No counter. And counsel appearing on behalf of the estate is not in a position to inform this court as to whether any decision has been taken on the petitioner's application dated 22/7/2024. So stop. List this matter on Monday as the first cases. In first 5 cases. So stop. The court will consider passing appropriate orders if in the meanwhile, if on the next date, and counsel for the state expresses his inability to inform this court about the decision taken on the aforesaid representation of the petitioner. Yes.
Item 23.
Monday. So we will take up every day. Monday till you take a decision.
On Monday, I will positively come with this.
But I have realized merely drafting letters is not enough. You have to ensure that the letters are issued, and it won't happen unless you take
I will do that.
yourself.
Yes, ma'am.
23.
May I please? Plus, this is a PI. My lords, I'm aware that the lordships insist on giving a representation in terms of Rule 8, my lords, but here there is, due to paucity of time, I'm filing this PI subject to your lordship's
I
satisfaction.
think the rules also mention that.
Yes,
if you
but
have not
however,
approved, you have to explain why.
if your lordships feel it to be that, my lords, urgent, then your lordships can entertain this. What has happened in this case, my lords, there were certain incidents in clinics across in Bhubaneswar and Cuttack, my lords, fire incidents. So the petitioner, who's a social activist, he applied for the institutions which are fire compliant under the RTI. And that is under Annexure 3 at running page 20.
Who is he?
He's a social activist. Malad, he resides in Cuttack in CDA, and he finds out that the stadium, the Barbati Stadium, wherein now an international match is going to be held, has not been made fire compliant, nor has it received a fire compliant certificate from the my lord's fire officer.
So
that is at running page 21.
You should approach the
Well, due to paucity of time, because it's a Herculean task, my lords. If your lordships
not an
monitor it,
Herculean.
because
See.
there's going to be an internet.
See, the chief minister of the state must be equally concerned about this.
True.
The officer who heads that department, he has also some responsibility, and he also must be.
True.
So why should we presume that they are not interested? Approach them.
And they may decide the matter expeditiously on a representation.
The present writ application in the nature of public interest litigation has been filed seeking following release. Stop. It is apparent that the petitioner has not exhausted the remedy of approaching appropriate authorities before filing the present writ application in the nature of public interest litigation, which is a requirement for filing of a PIL under the rules now.
Rule 8.
Accordingly, this application is accordingly dismissed, but with a liberty to the petitioner to approach appropriate functionary of the state, raising the grievance as has been raised in the present writ application. Yes.
Well, your lordships may say they may decide the issue within 3
What
weeks.
is the difference between this allowing the writ petition and giving you liberty?
No, my lords. They may decide it expeditiously because,
Pursue. We don't know.
because February is the match month.
See, we don't know. Match, they also must be knowing.
Yes. Certainly, they must also be.
Item 25.
Upon 20.
24 already done, my lord, not principal.
Please, your lordship.
25
Lordship, that matter, your lordship. No, the last occasion, your lordship had directed you to file the compliance affidavit by 26th.
I have received written instruction. Government is working on implementing the lordship's order, and my lord, on the verge of completion, the process, only issuance of letter, posting letters are awaited, my lord.
So we will also wait. Unless that is done, we will not close it.
Yes, my lord. Within 2 weeks, that posting.
2 weeks, Mr.
Yes.
I leave it to your lordship.
But that
Your lordship had done much of toil to decide
on the basis of the written
and in
instruction,
the
I have
meantime,
submitted.
your lordship, 5 months have gone.
Let us see. And then counsel representing the opposite parties has submitted that steps are being taken to ensure that this court's order, violation of which has been alleged in the present contempt application, is fully complied with as expeditiously as possible. So, as requested by him, the matter is adjourned to 2 weeks. So, if by the said date, the next date, the court finds that the order has not been fully implemented, the court will consider initiating contempt proceeding against the opposite parties.
Your lordship.
Item
2 weeks means 2 weeks.
Item 39.
My lord, we are appearing for the opposite party.
Yes.
This matter, if the opposition have filed a objection, they will for yesterday, 170 pages. That's what I've mentioned. It can be taken up next week. I have to go through this objection.
What is this matter about?
Matter is regarding, my lord, there was some disturbance in the institution.
Yes, we remember that.
Yes.
So if you can't run close it. Close it if you can't do it.
For the instruction that the President has made an inquiry yesterday, your lordship. We filed report also, your lordship.
All right. As requested. If you can't manage, you close it.
I guess.
As requested on behalf of the estate, list this matter on next week.
Item 40.
My lord, I am sorry. I may be pardoned, my lord. Can it be 1 week after? Which is next week? I am little inconvenient. $39, my lord.
Yes. Who is for the other side?
Have you given him a copy
Similar
of the order? Have you given him a copy of the order?
No, just now I am.
Just where is the order?
Condonation of
Order which are page 17A minor of their writ appeal.
17, page 17,
17A
page 17.
minor, page 17.
It will depend on the facts of the case.
Next year one.
So the facts were same.
Yes, ma'am.
Facts were same.
Same.
Can you see this, sir?
My lord,
We'll take up it.
I have
Take
seen
up
it.
the, huh?
I have seen this fact.
All right, it is applied.
Sorry, what?
In terms of the same order.
Same order, it can be disputed.
Condonation or delay? Condonation. How much delay? Delay is
539 days.
condoned.
887 days delay.
All right, okay.
41.
P1.
Last occasion, as per the direction, the judgment of hotel cases are being supplied, counsel for the state and also to your lordship final for verification.
Judgment of what?
For different persons who have taken the shelter of this honorable court, then thereafter went to the Supreme Court, so to confirm this same, and thereafter they have been regularized. I have given all the decisions and also my date chart I have given last occasion to your lordship my lord, showing the decisions and also the date charts. And he has to verify whether those decisions are applicable in discuss in the same department, my lord.
Department judgment are there. It's all right. There is no problem over there. But his continuance is, there is break in continuance. 3-4 times.
Where is the order which is under Sharon?
Order of the single page is at page 21, Annex of 5. Relevant portion is at page 25. May I please-
No, but no opportunity was given to file counter affidavit. How can you say?
No, my lord, they have appeared, my lord, with respect to that extent, my lord, may kindly see the order sheet that has been reflected, my lord, at para 12, my lord. Mr. For contra, Mr. Walshman, sir, on a counsel for the state, opposite parties, relying on this stand taken in the counter submitted that in view of the disengagement of the petition for certain period, the petition is not covered by the decision of this court as relied on by
Mr. Counsel, your writ petition was disposed of on the basis of certain statements made in the writ petition.
Yes.
Whether the state was given an opportunity to controvert those facts. There is difference between oral submissions made and the pleadings. So the writ petition was disposed of because of.
Rather, they are taking time, but they have argument.
Yes.
That doesn't mean. And you have not paid the time. As your lordship, Mr.
Your lordship may kindly see para F.
Just 1 minute.
Yes, time was granted to you to file counter affidavit. You did not avail that. You did not avail the opportunity. Then seek review if you want.
Correct. What I was submitting, my lord, in page 7, among the grounds, I have taken a ground, the para 44 of Secretary State of Karnataka versus Manipulated Judgment. Last 10 lines, may I read if you also permit. Page 7, it has been reflected. In that context, the Union of India, the state governments, and their instrumentalities should take steps to regularize as a one-time measure the services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts. Here, post is not sanctioned and there has been breaks.
Post not sanctioned
and there has been breaks. Continuous 10 years. It is not a case of continuous 10 years.
How much is the break?
Break, several breaks are there, my lord.
Breaks for what?
For a period he was appointed. Thereafter he was disengaged. Thereafter once again he has been appointed. That is how breaks are there.
Total years? I mean, forget about the continuous.
Total years, it will be more.
How much?
That I'll have to calculate.
So every year he's being employed for a short period.
Every year you are there for certain period.
Yes, what is your submission?
That extra, my lord, I have last time kindly the decisions which have been passed by the Supreme Court, I have also given, and my kind of matter justice, Mr. Ratha was also one of the four judgments are there on the basis of that.
No, if you keep saying that, I have a right to disagree with my own decision. I have a right to disagree with my own decision also.
But to that extent,
yes.
Decision of the Supreme Court, my lord, I also, fortunately, my lord, may kindly, if you assist for me, some my lord, may kindly see in similar circumstances, in similar cases that I will give in my lord. The proceeds for just yesterday, fortunately, I was able to get that decision, my lord, in the similar circumstances, because situation, page 17, my lord. First of all, I want to dwell para 15, my lord. Here in this case, my lord, this is the fact like this, my lord. They have filed 1% filed a petition. Number 17.
So this is the judgment which you were showing earlier also. Yes. This is different. This is different. This judgment we have considered in one of the decisions recently. But the fact remains that your appointment was against non-sanctioned.
Yes, but that existing vacancy as for Annex 1, they have enclosed, my lord. In the writ of appeal, kindly see in Annex 1, existing vacancy. And also, with your Lordship's permission, the decision which I have with your Lordship, may kindly see the first decision, the person who went to the Supreme Court, my lord. May I place that I have already given, madam. Kindly see that.
Mr. Counsel, your engagement was
existing vacancy.
How do you say?
Yes, madam. To that Annex 1.
Annex 1 to?
To the writ of appeal, my lord. At page 14, my lord. 8th line of that order.
Yes.
Existing vacancy.
What is the date?
That's next page, my lord.
What is the date of this?
26/8/97, my lord. Next page at 15.
26/8/1997.
26/8/97, August.
Next page.
Much obliged. Page 15.
Yes. Then
Thereafter, my lord, by continuing as such, they have published right to be settled of the tribunal, my lord. And tribunal, as per Annex 3, my lord, page 17. Ordering portion, may kindly see.
No. 2002, it was again terminated.
Yes, my lord. Then there are to be settled of the tribunal, my lord.
Now, on the strength
Order
of
of the past.
Is it?
Yes, my lord. Then tribunal passed the automatically relevant portion at page 19, my lord.
Yes.
What is my lord? May I please?
Yeah.
Paragraph 4. In the constructors of the facts and circumstances, we feel that ends of justice will be met in any kind. Is allowed to compete along with others eligible for appointment to the post of FMD for which regular vacancy exists should not be debarred for age and should be granted the concession of the age from the date of his first appointment as FMD until the date of advertisement for recruitment to the post on regular basis. The applicant will continue the post he is holding until he is thus considered for it. This is of the year 2002. Yes, sorry, 27/7/5. So my response to 74 will be that thereafter, my number of persons in the subsum department has been terminated. They took the settle of the tribunal. Tribunal allowed them. Then the state government come to this honorable court, and honorable court also confirmed against that the Supreme. They went to the Supreme Court. Supreme Court dismissed the same. My lordship's permission. May I place that I have also given the decision to your lordship for permission last occasion. To the lordship, may I place my lord? The Supreme Court decision so far the state of Orissa versus Narayan Patnaik. In that case, my lord, in SLP, those petitions were called on a hearing today on 18/7/2021. Then thereafter, the order of the past, the special leave petition are dismissed. So the order which has been passed by the tribunal and also the honorable court was confirmed with honorable Supreme Court of India. Then thereafter, we can see another person also in similar circumstances. Their service are terminated. They took the settle of the tribunal, and thereafter the government come to this honorable court, and thereafter keeping in the decision of the honorable Supreme Court of India, that was allowed. That is also another decision in Ramesh Chandra Mahapatra versus Susila, and when I was arguing as the counsel, I was arguing this honorable court also allowed, and they have been directed to be regular. Accordingly, they have been regular and getting this. This is the decision of 5/8/22. Then thereafter, my lord, I kindly see in the said judgment that is also reflected in page 4, para 7. In the meanwhile, some similar placed persons approached the OAT in different ways, which were allowed. The orders of the OAT were challenged by the state in this in WPC number.
There is something which we might have missed to understand. Your services were terminated. You challenged that order before the tribunal. What happened finally in the tribunal? Whether your termination was set aside or you...
And I allowed to continue. Next order is there, Annex 3, Annex 4.
Read paragraph 4 of the order.
Yes, ma'am.
Page
Yes, ma'am. Yes, ma'am. May I please, madam?
Yes.
In the constructors of the facts and circumstances who feel that the ends of justice should be met if the applicant is allowed to compete along with others eligible for appointment to the post of FMD for which regular vacancy exists, he would not be debarred for age and he would be granted the concession of the age from the date of his first appointment as FMD until the date of advertisement for recruitment to the post of a regular basis. The applicant will continue in the post he is holding until he is thus considered for recruitment. Then thereafter, Annex 4, the authority allowed to continue, my lord. I am continuing now, my lord, till that.
What about that appointment when you were asked to continue, be considered for regular appointment? To participate in the,
They did not carry out, my lord. Even if that order they have not challenged, for which I was forced to file this OA application to carry out the same, my lord.
no, they gave you a chance to participate in the recruitment for
No
regular.
recruitment was held, my lord, till then. For that reason, with great respect, I was forced to file OA for a direction to carry out the order which has been passed by the Honorable Tribunal, my lord. To let the recruitment help, but in the meanwhile, my lord, I have given the decisions of different persons. They were appointed ad hoc basis. Their services are terminated, and they have been regularized keeping the order of this Honorable Court, with my lord also as a party keeping.
Let us see the order of the tribunal again.
My lord.
Where is the order of the tribunal? Let us see that again.
Pardon?
Order of the tribunal.
Order of the tribunal, my lord. This is the order, annex of
No, sorry, 1 or 2.
Annex of 3. Annex of 3, my lord.
Three?
Ordering person which I was placing, that is the ordering person of the tribunal, my lord.
Page 17.
Page 17. So last ordering person, page 19.
So this is the subsequent order. I am saying when your first order of the tribunal, that is the order.
Yes, my lord, not obliged.
First order.
This is the first order. As because that is not carried out, my lord. So I took the shelter of this Honorable Court by filing another one. Because that was abolished, for which that was transferred to this Honorable Court. Honorable Court, after taking into consideration, passed order by annex of 5. I am continuing till that way.
By virtue of order of the court.
Yes, my lord. Annex of 5, my lord. To which they are challenging, my lord. Ordering person is at page 25, para 15.
We will see, we will pass appropriate orders. Heard so and so. Put up for judgment 4 weeks.
We will all the decisions last of
We will consider everything.
Item 42.
See, we are also trying to understand the law of regularization.
Honorable Supreme Court of India, my lord. In self-same department, with that respect to that extra, my lord, in self-same department, number of persons have been terminated and also took the set of tribunal, the High Court, and also the Supreme Court.
We are just understanding.
Not
that simple for us.
Your lordship.
We are just trying.
Yes, much obliged.
Item number 42.
May it please your lordship. Petitioner is working as a programmer in the establishment of this court, High Court. He is now seeking upgradation of his post to that of system analyst, the higher post. Petitioner joined in 2014, and one system analyst also joined.
All right, we will assign this case to some other bench. The matter, in this case, go out of our board to be placed before an appropriate bench under the office of the Chief Justice.
Item 43.
The issue involved in the present case is threefold. In the present case, respondent is a contractual employee who is deemed to be terminated on the expiry of the contract period or the renewed period. In the present case, the learned single judge erred in not considering the fact that the contractual period had actually come to an end, and also the renewed period up to which he was extended, that was also that was still 3/3/2016, and thereafter. And one more point which was not considered by the learned single judge was that the respondent do not have any vested right to be continued as a contractual employee. Once the term of the contract comes to an end, his employment automatically terminates. And for that, my lords, if I can speak to the relevant documents in this present case. So, my lords, page number annexure 2 of the writ petition, page 19. 19/12/2012 is the appointment of the petitioner.
Just a minute, madam.
Annexure 2 of the writ petition.
Annexure 2 of the writ petition.
Yes, my lord. 19/12/2012, the document date.
Yes.
Serial number 3, the respondent name is reflected. And point number 3, my lords, the contract is initially for a period of 11 months. This was renewed timely. And on 5/6/2014, the contract was renewed till 3/1/2015. That is at annexure.
No, this was dated 19/12/2012.
12. Yes, my lords.
So this came to an end on 19/18/11/2013.
Yes, my lords.
Then what happened?
Thereafter, the appointment was renewed, and it was renewed till 3/3/2016.
Renewed till 2016 from time to time.
Yes, my lord.
Yes.
Annexure 4 at page 22
Yes.
is dated 5/6/2014, wherein the contract was renewed till 3/1/2015.
5/6/2014. So it was renewed till
3/1/2015. This is the annexure 4, page 22.
yes.
Thereafter, 3/35/2015. Again, it was renewed till 30.
So it was we accept that it was renewed from time to time till 3/3/2016.
Yes, my lord. But annexure 7, I want to draw your attention at page 29. Annexure 7 to the writ petition. Page 29.
Yes.
My lords, last 3 lines in the first portion. Agreement of those staff who are under observation up to June 2015 shall be renewed after obtaining remarks of reporting and reviewing authority.
Where are reading page?
Page 29, the office order.
Office order.
Last 3 lines of the first paragraph.
Yes.
The agreement of those staff who are under observation up to June 2015 shall be renewed after obtaining remarks of reporting and renewing authority based on performance of the said quarter.
Yes.
My lords, respondent name reflects at serial number 27. Under observation up to 30th June 2015. At page
Yes.
23.
Yes.
Again, my lords, on 5/1/2016, at page 35, annexure 9.
Page
35, annexure 9. Again, under observation till 4/12/2015.
Yes.
Next annexure, annexure 10, page 23 to 2016. Well, sorry, and page 36. First, I wanted to show.
Yes.
This is dated 5/1/2016. If I may read this document. It is to inform you that as per the remarks received in previous PAR performance appraisal report for the period 2014-15, your performance rating is good. My lords, here good does not mean in the common parlance. It's described, I'll show you after this. During observation period, your performance is also rated good. It shows no improvement has been made on your part for improving your performance. This is the reason why in the previous orders it is under observation. And thereafter, annexure 10 at page 37. This is the final extension which he was granted. Here also, it is specifically mentioned that his performance, there is no improvement has been made on your part for improving your performance. At page annexure 10, page 37, minutes. And therefore, you are warned and given opportunity to improve your performance by 3/3/2016. As the contract period is extended up to 3/3/2016. If you fail to improve, no further renewal of your engagement contract will be accepted. And finally, on 27/2/2016, Annexure 12, page 39.
Yes.
Here, I'll just read this document also, my lords. Your previous term of agreement for job contract with us expires on 3/3/2016. As per the decision taken in the contract renewal committee, further extension of your contract is disallowed beyond 3/3/2016. Hence, your services are terminated with effect on 3/3/2016. After this, my lords, I'll just show two more documents. First is the contract, one of the last contract dated 5/1/2015, which is part of the counter affidavit because of the opposite party in the petition, Annexure A3. Here, I'll just read one clause, my lords, at page number 11 of the counter affidavit. The second party shall neither have any right or lien on the contractual job, and services shall be automatically terminated at the expiry of the contract period. In this specific document, the contract was still 4/12/2015, but as I showed in the earlier document, it was extended till 3/3/2016. So there is an automatic termination on the expiry of the lease contract document or upon the renewal time. The relevant guidelines which are issued by the government, first is at page number 19 of the counter affidavit, they are dated 1st October 2011.
19 of the counter affidavit.
Yes, my lord.
Yes. Yes.
Clause serial number 4. All the staff whose work is APRs are recorded outstanding, very good, may be allowed to continue in the service and shall discharge all function after completion period pending renewal. In case of those staff whose performance are recorded poor or average, the concerned reporting officer should give adequate justification for substantiate such remarks, and the concerned staff should be refrained from exercising any financial power. Next, my lord, serial number clause 7. At page 20, those employees whose performance are rated good would be given warning letter to improve their performance in future. So this is how under observation comes into the picture and how we had actually given them warning. And finally, one more document, my lord, which is at page number 16 of the counter affidavit, 10/4/2015. At page number 17, clause 7.
Yes.
Those employees whose remarks were recorded in PAR, performance appraisal report, as good for 2 consecutive terms, their performance have been of minimum utility for achievement of mission objective and not having been improved from previous year mediocre performance. The performance will be kept under observation for 2 quarters. That is how 2 quarters are 35/2015 and 5/1/2015 to 36, and the 36 till the end of the year. Date expiry of last contract period with a day break in between. The date of expiry of the last contract period and commencement of the observation period. Then, my lords, if I may come to the include order.
Yes.
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 Include order at page number 55.
Yes.
Here, last paragraph. Here, the learned single judge has actually
Internal page.
Internal page 37.
Yes.
Here, the learned single judge has actually gone on an assumption that we had terminated this contract during the subsistence of the contract, but the contract itself was not renewed after 3/3/2016, and it automatically came to an end. And second, here the direction has been issued to us to reinstate the contractual employee at internal page 38, last last four lines, if I may read, there cannot be an automatic termination, but as per the contractual provision, there is a clause for automatic termination. And if I may just refer to one judgment of the Honorable Supreme Court.
Hello.
2018 BSCC page 218. Para 6 of this judgment. Just read, my lords. Para 6.
Yes.
Para 6. It is a settled law that no contract employee has a right to have his or her contract renewed from time to time. This judgment in question was regarding regularization only to show that this portion that contractual employee does not have right of automatic renewal. I'm just placing reliance upon this judgment. If I may just conclude, the only point here is that the contractual employee's term came to an end was not extended, and it was as per the guidelines issued by the government and as per the contractual contract document. These things were not taken into consideration by the learned civil.
Yes. That's all. Yes, how long can you continue on the basis of that contractual?
Because one thing, Lord, the project is continuing, others are continuing. For that, one line that I can say, whatever my friend is reading, just I'm reading again, Lord. The contract is initially for a period of 11 months or till the end of the project. That very part is there, and almost all around 40%.
See, there are two things. The contract is for a period of
1 year, 11 months.
1 year, or till the project continues. So the second condition is a condition where in no circumstance that can continue.
No, that is not. You're also right.
All right. So we are not with the second thing. Second, if the second condition is there, then in no circumstance you can continue.
No.
The question is that with the first circumstance, how long can you continue? This is the question.
This is the question, my lord. In answer is, my lord, the other person is continuing, and there is also no whatever the stated. You also kindly see the termination order. The order does not say so, my lord. If my performance is bad, then they can out, my lord. And that too during substantial contract, I was terminated. The 2 points I want to bring on lordship notice. That has been dealt with by the honorable court. Lordship kindly see the input order where I was terminated. Kindly see that is.
No, that we have seen that you are good, and despite that you have been removed.
No, that is one thing. And another thing, Lordship, I have to point out, Lords. The contract was up to 3-3. I was terminated on 27. Lordship, see. That means, and that too, that is a stigmatic one without giving opportunity.
There you may be right.
Yeah, Lordship,
stigma.
Just one thing, Lordship. I am just reading. What my Lordship said. This is also, I am reading on their record.
Okay, we will not interfere anymore. Please make your submission.
Sorry, Lordship.
Please make.
Just I want to bring a Lordship notice.
Sorry. Please do it.
In view of the various irregularities observed in your activities during your tenure as accountant, it has been decided by the Contractual Committee that your service are no longer required. Your previous term of agreement for job contract with us expired on 3/3/2016. As per the decision taken in the Contractual Committee, further extension of contract is disallowed beyond 3/3/2016. This is the matter. And whatever they stated that the contractual the renewal committee decision was taken on 6 on 6/5, but the renewal was made that was on 23/2/2016. If my performance, my performance was good. There is no such record, they have not produced this is a specific stand. And even if the performance is bad, my lord, suppose that on 23/2/2016, that has been dealt with by honorable court. My performance was should be good. And how prior to this period, my performance was bad without any records. And that has been dealt with just 2 paragraphs I'm reading. Lordship's plus convenience. Only the honorable single judgments, only 2 paragraphs in that. I am permitted to read now. Everything has been dealt with. And this is a stigmatic one. And only because there is some dispute in me and the other junior person, they are continuing. Let's kindly see the 53 of the para 26 of the interim judgment. Just I am permitted to present. From the pleading of the parties, as detailed above, so above the submission made by the Lord Counsel for the petitioner, it is amply clear that as per clause IB of the guidelines, letter 1/10/2011, all staff whose remarks are recorded as outstanding, very good, may be allowed to continue into the service and shall discharge all function after completion of contract period pending renewal. However, in case of those staff whose performance are recorded as poor, average, the concerned reporting officer should give adequate justification to substantiate such remarks, and the concerned staff should be refrained from exercising financial powers till receipt of order of renewal of their contract from the mission director. Similarly, in the clause such and such, the said guidelines, those employees whose performance are rated good, they should be given warning after to improve their performance in futures. Whereas in terms of clause 9 of the said guidelines, those employees whose performance are rated poor, their contract service shall not be renewed. That is the one thing. Then let's just para one thing. Office order dated 5/2016 and 23/2016 under answer 9 series shows that the year of the petition was treated as good. Further, it is well evident from the order dated 5/2016 as an answer 9 series that the contract renewal committee, based on the remarks received from the individual performance reflected in the PR of the petitioner, allowed renewal of the contract with retrospective effect from 4th December 2015. Thereafter, the communication dated 23/2016 as annexed such and such was communicated to the petitioner that as per the remarks received from the previous PR such and such, his performance was rated good in both the PR. Accordingly, the petition was renewed and given opportunity to improve his performance by 3rd March 2016. At his contract period was extended up to the set date, indicating therein that if he fails to improve, no further renewal of the engagement of the contract will be accepted. But surprisingly, the termination was passed immediately 4 days after 27/2016. The said conduct of the opposite party being contrary to the circular dated 1/11/2011, so also the office order dated 10th April 2015, as quoted above, the court is of the view that the order of termination dated 27/2016 at Annex 12 is illegal and liable to be set aside. It may noted here, pointed out, mentioned here that though para 9 of the counter, it was admitted that PAR of the petition was good, but contrary to the said admission, in PAR para 13, the said counter of the stand is taken that the PAR of the petition was rated as poor, for which his service was not renewed. Such stand of the state opposite party is contrary to the contention of the letter dated such and such, which was indicated in PR such and such. Further, the so-called inquiry was conducted after terminating service of petitioner. On getting his grievance petition, as has been admitted in para 7 of the counter, read with the report such and such, the service of the petition was terminated on 3/3, while letter dated 27/2016. Whereas the Alice inquiry is conducted on 12/5 after 2 months. After 2 months of termination, the inquiry is conducted. That is the admission of the opposite. And 4/8/2016. Such report also does not disclose any date on which it was signed and submitted to the officers of NSL, who are members of the said team. In view of the stand taken by the state opposite party in its counter, that action was taken based on inquiry conducted by the medical officers such and such, no suit was being issued to the petitioner for such alleged misconduct. This court is of view that there is violation of principle of natural justice. The alleged inquiry conducted after termination of service, the petitioner has been the after termination of service of the petitioner, as has been observed above. Apart from this, the contract renewal committee, in contrary to the order dated 10/4/2015 of the mission director, this court is of further view that even though the petitioner was appointed on contractual basis, there cannot be automatic termination of the service without affording an opportunity of hearing. and following the principle of natural justice, here the action of authority is being illegal. So in entire para, whatever the stand taken, that is considered by them. And more particularly, they said that inquiry is conducted based on inquiry, I was terminated. But the inquiry is conducted after my termination. And that too, the subsisting that contract as per the this APR millers, my contract was renewed, and during renewal miller, just after 4 days, my contract was terminated, and the termination is stigmatic one. And the guidelines or the whatever they said, that 11 guidelines, that doesn't say the action terminated. Whenever that is poor or the less than poor, then he should be terminated. But my service is good. And on the basis of the PR, you are telling me that is extended. But how you can say that that is not good, or that is bad, or that is poor? And no records are produced. And more particularly, the inquiry is conducted after the termination. This is the entire submission. I have realized the entire and everything, all the records are there. The honorable signatures applied his minds. So this is entire.
I'll only stress one thing. Here, good does not mean in the common parlance, because he was rated as
That we have
good.
shown.
He was under observation for a year.
We'll see.
And the other persons are continuing, almost all persons.
Is this your submission that you have right to extension?
I don't follow it.
Right to extension. If suppose your contractual appointment is for a particular period, then if that period is over, you have a right.
No, that is not my submission. My submission is they may not extend. That is up to the authority, subject to the guidelines. The guidelines say if that is poor or whatever this is this.
Therefore, we are putting this question. We are sorry that we had to put this question. I didn't want to put the question. Still, for clarification, that if you fulfill all the conditions, you have a right to extension. This is what I want to know from you.
My question in that context, I have not.
Am I not clear?
No, I'll give you an but only one thing.
Is this your submission that
putting one question to myself, Lord, the project is continuing and the juniors are continuing, and that too.
Mr. Ark, my question was very simple. I wanted to know: is this your submission? All right. Is this your submission that because your juniors have been allowed to continue, you have right to extension if you fulfill the conditions? This question is more appropriate?
Yes, that posing that questions. But in that respect, my submission is because once they were terminated, so the termination is bad. Then if the termination will go Millard, then Millard's the consequence follow Millard's. Once they have stated that termination is bad.
What is the consequence?
Consequence, they are allowing others, and my performance is good. So this is my entire submissions. And more particularly is a poor man.
Your performance is good. Your employer's performance is not good.
No, I cannot say so.
No, you will have to say.
Only the dispute Millard. That is
all right.
And in that respect, I can file a judgment for lawsuit complaint. I can file a judgment. If whether right to continue or not, even after expiry of that contract period, that I can do. More particularly, the others are continuing.
Third. 4 weeks ago, the date.
Item 44.
Apart from the Odisha Public Service Commission appeal, there are 3 more appeals that have been filed. There's a matter relating to.
No, all the appeals have been filed by OPSC.
OPSC has filed only 1 appeal, my lord. Other appeals have been filed by those candidates who appear in the examination.
This relates to what?
This is relating to, my lord, drug inspector appointment.
Yes.
Under the Odisha Drugs Control Service, Drugs Control Administration, Method and Recruitment Condition Service Rules 2020.
Yes.
Before taking your lordship, my lord, what has happened in this case in the capsule, my lord, I want to bring to lordship's notice. What has happened in this case? One candidate filed a writ application before this honorable court
stating therein that the question papers were not in accordance with the rules which
Yes.
was there for the purpose of calling for this, my lord, written examination. Lordship, may kindly come, my lord, for a minute before I take your lordships to the impugned judgment of the Central Court of Appeal, my lord.
Yes.
Lordship, may kindly come to page 20. That's the advertisement.
Yes.
This advertisement was published on 5/9/2022, my lord. Lordship, I'm just placing it,
Yes.
my lord. The recruitment online applications are invited from the candidate through pro forma application form made available so and so date, my lord, for recruitment of 47 posts of Drug Inspector Group B of the Orissa Drugs Control Service, Drugs Control Administration under the Health and Family Welfare Department in the scale of pay of so and so, my lord, as admissible from the government from time to time. The recruitment will be conducted in accordance with the provision of the Orissa Drugs Control Service, Drugs Control Administration Method, Recruitment and Conditions of Service Rule 2020. So, Lordship, may kindly see the number of vacancies for which it was there was for 47. Now, Lordship, may kindly come to page 23. Page 23, my lord, of the advertisement.
Yes.
The selection of the candidates for recruitment to the post shall be made on the basis of written examination of 200 marks.
Page 23.
20,
Yes.
22.
22.
Number 23. It's 23.
Pages are different. Pages are well.
Page 23 or 22?
Well, the 23, my lord, the method of selection.
Method of selection, page 23. Yes.
Now, the selection of candidates.
Yes.
For recruitment to the post shall be made on the basis of written examination 200 marks.
Yes.
Objective type, multiple choice questions. Then, my lord, personality test, 20 marks. The standard and subject of examination for recruitment to the post of drug inspector shall be as follows. The written examination shall be in the standard of Bachelor of Pharmacy, Pharmaceutical Science, or Doctor of Pharmacy. The written examination shall consist of 200 marks, shall comprise of multiple choice questions only. Each question shall carry 1 mark and 0.025 marks shall be deducted for each wrong answer in the written examination. The duration of the written examination shall be of 3 hours.
Yes.
The Lordship, kindly mark, my lord, the subject of examination shall comprise of pharmaceutical chemistry, medicinal chemistry, pharmacology, pharmaceutics, physiochemistry, all those 8 subjects, my lord. And for 8 subjects, 200 marks, my lord, was there. The syllabus for written examination will be as per the syllabus approved by the Pharmacy Council for India for Bachelor of Pharmacy, Pharmaceutical Sciences, or Doctor
Yes, yes. So what happened?
My lord, thereafter, what has happened is the petitioner came to the Honorable Court and he said that it is not in consonance with the rules, because as per the rules, you should have given 25 marks of each of the papers. So he segregated that if the questions have not come from one paper, 25 marks, then the examination is bad in the paper. So, my lord, we have filed the report of the, my lord, the expert committee.
No question of report. What is the decision?
The decision, the whole selection has been passed.
See, it's
the whole selection has been
At the instance of one person.
one person. Selection of all candidates is set up.
On the ground that
Yes, sir.
The total
And
200
nobody
marks.
has challenged the advertisement also.
No one has challenged that.
Like it's like this. Total 200 marks. 8 subjects. 200 marks covering 8 subjects. That single question is not beyond 8 subjects. It's only of in
Within the syllabus.
Syllabus.
within all in syllabus.
someone is appearing for the other.
Yes. And that the candidate who has come, who has filed the writ application, he has not qualified on the written.
He appeared in the written examination.
But he was not qualified. We all candidates have appeared the written test, qualified, Mahavas test, qualified.
We are not made party.
We are not made party.
By that time, my lord, the selection was not over, my lord. So, yes. My lord, similar. My lord,
Same respondent in all the cases.
Only one respondent.
Yes.
One judgment, my lord.
Yes.
Page 46, my lord, the rule is at Annex 3, my lord. Page 46 of the writ appeal. My sole ground, my lord, before the single judge, my lord, they have not followed the rule while preparing the question papers. My sole ground, admitted. Rule 6, my lord, page 49, you will have seen that. 49, my lord. This is the table, my lord. Yes. In the rule, my lord, the table, all the 8 papers are there, my lord. Against all the 8 papers, in the rule, it has been prescribed 25 marks from each paper. Subject. So that was violated. That was violated while preparing the question paper. Where is the rule? Rule, my lord, page 49, my lord.
49.
The rule starts page 46.
No, still.
The rule which you was referring to, that is the rule.
Yes, ma'am. Yes, ma'am. That is the rule.
Page
46 of the appeal, my lord.
46 it starts.
In my writ petition, that is Annex 3.
No. Rule you tell us, part 3, direct recruitment or what?
Rule 6.
Which portion?
Yes, yes.
Rule 6, yes.
Rule
right.
6, my lord.
Lots of right, man.
Part 3.
Rule 6.
That starts in part 3, direct recruitment.
Page 49.
Page 49 is the table. That is the
But they have forgotten to mention the rule, it has been deleted from the.
No, it is not there somehow, I think.
Maybe Xerox or something might.
No, but 49 says that 45 marks will be for this.
Yes, yes.
25 for this.
paper paging is my lord.
6. 49.
49, my lord. That's
Turn page
table
4.
Subject of examination shall comprise of.
Yes.
No problem.
So in that rule, my lord, it is categorically prescribed 25 marks from each subject.
Yes, you're right.
And my lord, since these 25 marks are not in the question sets, my lord, petitioner after appearing the examination or the counsel approached the court. By that time, no result was found and there was no chance for him to make the others as a party, my lord, as my learned senior as my lord. Then, my lord, on their own, they submitted an expert report, my lord, expert opinion report. In that report, they admitted that there is a deviation in the rule. Based on that, learned single judge passed the appeal.
Yes, Mr. Rautra. So, learned single judge appears to be right at least because the advertisement was not as per the rules.
Nobody questioned the advertisement. Advertisement said the total mark is 200.
No, advertisement might have said that. But the recruitment was required to be done in accordance with the rules.
Each subject is 25 marks.
Yes.
That has been, let's say, look to the expert
committee reports.
That's exactly the crux of the matter. Let's say, look to that.
Page, my lord, I have annexed it. Page 111. 111.
Annex 5.
Annex 5. Expert opinion on the syllabus for recruitment to the post of drug inspector pursuant to advertisement number 1. Pharmacy is a multidisciplinary science, and no strict boundary can be set between the pharmaceutical chemistry and medicinal chemistry, hospital and clinical pharmacy, pharmacology. They are all interrelated.
See, Mr. That submission which you are making can be accepted, but the question is the rules provide that there should be such and such 20. This questions should be paid for 25 marks for this paper. So in the question paper itself, it ought to have been there that this is the subject 25 questions for that. And then you can, if that is challenged, then you could have taken a plea that they are interrelated subjects and therefore framing of questions cannot be questioned.
My lord, we had done it for the 200 marks as per the advertisement for all those subjects. All subjects were being covered. And 200 marks, each of the subject, my lord, 25 marks. Now, what we have stated, my lord, since it is a multidisciplinary science, so it was difficult, my lord, to segregate it. Because subject-wise segregation was not possible.
See, it was not difficult for you to segregate it. It's a different question whether he could, the petitioner could make out a case that for a particular subject, no question worth 25 marks were there in the question paper. So whether they could make out this case.
No, my lord, they themselves, my lord, we have given all those questions and we had called for also, my lord, the objections. He never gave us any objection. We advertised. Lord, may kindly come to page 100, my lord, of my.
You had called for objections?
Yes. 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 Lord, may kindly come to page 100. After the examination got over.
Not after the examination. After the examination, you called for objections.
So, my lord, examination.
All right.
Page 100, may kindly. Yes, in mind.
Erroneous questions.
Yeah, it is for the information of all concerned that the Commission welcomes inviting objections from candidates on erroneous questions and answer options in objective type examination within 3 days from completion of the said examination, so that the same can be placed before the subject experts. So whatever we got, accordingly we placed it before the expert committee. And expert committee said, my lord, that there can be no segregation. As you lots of know, we get the requisition and we appoint, my lord, the question setters.
No, but seems that there was some pleading in the writ petition also. Paragraph 10.
After we filed the counter, my lord and friend had filed some documents from medical pharmacology books, my lord, by filing a adjournment.
No.
Yes,
They were objective type.
Yes. Yes, ma'am.
Why did you not raise any objection when the
result was not published, my lord?
No, not results. When they invited objections, when the
objection was prior to my lord, my writ application, my lord, no objection. That was 100, page 100, your lordship may kindly see again. Page 100, my lord, that that is the letter dated 13/8/2021 in relation to another advertisement. And this is the advertisement of. No, my lord, I'm sorry.
So you filed the writ applications after the results were published?
No, after the written examination.
After the
written examination, you challenge. But did you? Objection was not called for in that advertisement.
This is not advertisement number 5600.
No, my lord, page 100 is what your friend, my friend Fulman, that is 100 is what I can see. That relates to of the year 2021.
Yes, is that notice in relation to some other
notice? The notice, my lord, for all the examination, this is the general notice that within 3 days you file it. All examinations, my lord. It is for the information of all concerned that the commission welcomes inviting objection from candidates on erroneous questions and answer options in objective type examination.
Regarding what?
For all the examinations, we
Seems Odisha.
How can you give a notice of the year 2021 for an exam which has been held in 2020?
Lord, we for every examination, my lord,
Yes.
we don't publish that, but at a one go, my lord, in
So
the
you will publish once in 10 years.
Odisha Public Service Commission website, we give it that for every examination, you file objections. And accordingly, we take it up.
So it must be there now also on the website.
Yes, my lord, must be there.
General notice. Yes, they have, you could have approached the commission. You could have approached the commission. There's a general notice which allows every participant.
That notice was not widely circulated. That relates to the particular examination. And nowadays, my lord, in every selection, there is an objection accompanied with answer.
Nowadays is over.
And
Nowadays,
also in that. Also in that. Because during pendency of the case, that was not widely circulated among the candidates. As your
no,
lordship,
no one has any grievance.
as your lordship deemed it proper.
And you are not going to get anything.
That is. He has paid.
But
Yes.
Yes, failed, my lord.
Even if we,
my seat examination again may not be selected, may not, that is not. If written test will be held, I will sit again.
What is your age? What is your age?
Age my lord, 28. As your lordship deemed it proper. But the honorable.
no, but you had raised a valid point.
But the honorable single judge, my lord, passed the order with the due diligence.
No, that yes.
And the para.
That we were under the impression, till we had seen the rule, we were under the impression that 200 marks was for this thing combined.
In total, your lordship. But
Yes, what is your submission?
The expert committee says that the balance, it's a balanced question set covering all the syllabus and all the chapters.
Suppose all the chapters and syllabus are covered, but from one chapter there is only there is only one question, and from the other 48. So
that has not happened, my lord.
It has not.
Subjects are interconnected.
What happened? You could have
Subjects are interconnected.
subjects are interconnected. Maybe interconnected. You could have taken a plea, this plea that you are saying 25. So these were the 25 questions. These were the questions for this syllabus of 25 marks.
That is what the committee expert has said.
Huh?
That is what the expert has said.
No, that is very vague.
If your lordship could see, they have given a chart.
That we can see. The chart we wanted to see.
In fact, that is just minor variation. It's not.
Let us see.
May kindly see in my brief. It is page.
No, it is 112. 112. It's there.
One second.
One second.
But in my brief, it is page 30. May kindly see. Just 3-4 marks. I mean 3-4 questions variation. Kindly see page 30. The committee says in this subject instead of 25 days.
WA, which WA?
But mine is WA 2371 of 24.
So it is that subject-wise analysis.
Yes, the committee has said it, but only 2-3 questions variation. That question coming in the other subject. It's not that it's not completely out.
Pharmaceutics, it seems there are
21.
Which annexure?
Well, this is the annexure 1, the judgment, part of the judgment. The Honorable Single Judge has reproduced it. The report of the expert committee, running page 30, internal page 15. Kindly see. Almost every subject.
That was reproduced in judgment.
Right.
Oh, so last they have given the abstract.
Yes, Lord. Abstract is this. Kindly see this.
That was the abstract.
See paragraph 3 subject-wise analysis of question paper.
They have examined whole 200 questions. And they have given an abstract, subject ones.
Except for pharmaceutical, chemistry, and medicinal.
Yes. They are since interconnected. Questions are overlapping from here to there only, but questions will remain same.
Can you also look to the abstract? The abstract that please show.
Yes, I am showing.
Paragraph 3 towards bottom.
Paragraph 3 end part. Last.
Entire 200 questions have been quoted. Then abstract.
The committee has taken note of each question. 200 questions. It starts from page 21, running page 21. Then the abstract is given thereafter. That's got it.
Yes.
Now your Lordship, see the petitioner tried to make out a case as if it is completely out of syllabus. Kindly see petitioner's grievance, page 120.
No, not out of syllabus.
They say
only one topic has been covered.
Lordship, kindly see. So the petitioner is giving pharmacology 48 questions. It's not that.
This is not
Is that out of syllabus? Does that mean that is out of syllabus?
No.
Exactly. That is his case, not out of syllabus. He said not.
48 marks comes out.
27 26.
Two, 3 papers, minor variation. That too, they are all within the syllabus.
That is there. Page 30 of his brief. You also look to the abstract. 25 marks each, except 3, where one is 21, one is
28,
20,
and both the subjects are
interconnected. Also look to that. That is very important.
To that also, my lord, I had filed an additional affidavit to the expert as per the direction of the London Single Judge. I had filed an objection to that. In that, along with the textbooks, I had filed an additional affidavit.
That we cannot read textbook and decide.
Expert of experts.
And further, my lord, from the abstract, irrespective of all the facts, my lord, from the extract and from their admission, the Honorable Single Judge, the entire analysis is para 8, man. 8 of the judgment. And this is my whole.
We will see.
With the due diligence, my lord, the judgment.
No, that is an review. Review is correct. In fact, we can issue direction for the future examination in this case. There should be a segregation type of a thing. When the rules require, then.
Or you amend the rule.
Yes.
Very easily follow.
Give the topic, heading also and give the questions.
Tuesday.
Great.
Deeply good.
To dictate.
45.
My lord, today I have received the affidavit by the collector. Let me verify that.
Verify what? That is correct or not?
Some information regarding the electrification and Contractual. Let me verify that whether that is.
That's been the last order.
See, the electrification we are finding is causing so many problems.
There is no electrification, my lord.
No electrification, and electrification is causing death of the elephants also, wild animals.
And that is only solar light they have given. That is page 12.
Solar?
Solar.
Solar they have given.
They have given it is out of order for the last 10 years.
That can be done.
Safe.
That is
Solar is
page 12.
safer.
Minor page 12. That is their affidavit. Page 12.
And it's reproduced at page number 4 of the counter affidavit.
All right, you consider and then come.
Previously electrified in off-grid, but it is out of order.
What is?
That they have mentioned that previously electrified in off-grid mode made by the OREDA, but it is temporarily out of order. That is temporarily means last 10 years.
No, out of order means won't you satisfied?
My lords, in the next column, the revival work is going on. It's what's mentioned in the status of the electrification.
Yes, ma'am. Madam, page 5, page 6 of the counter.
All right.
Let me find the affidavit, that would be better.
You will file affidavit.
Yes.
Take instructions, affidavit may not be necessary.
Yes, ma'am.
Just take instructions.
Take orders rather, instead of you can issue directions.
Yes, my lord. Always I find a detailed affidavit. What is the wrong there in the affidavit? But my lord cannot pass.
No, why affidavit? On the next day,
yes.
See, you have filed your writ petition. You have seen their counter affidavit. Now they have admitted that there are deficiencies.
So my lord will direct, but let me get that information. I can submit that. My lord will pass that.
All right, but don't file affidavit.
Not necessary. I shall give a charge.
And counsel hearing on behalf of the petitioner states that he is required to consider the counter affidavit which has been filed on behalf of the estate. So, as requested, let's this matter on 1 week. 2 weeks. 2 weeks.
Item 46.
2 weeks. Yes.
46.
Item 46, my lord directed to file the counter, will requested for filing counter. My lord, give me another 10 days time, then we will file the counter. We have already received the PWC. By 2 weeks, after 2 weeks, we will file the counter. Copy also sub the other side.
The monument is demolished since page 42, ma'am. Page 42.
So let him file counter affidavit.
Demolished, page 42.
The FIR is lost, so the action by page 42, the contact sub-circle.
So let him file counter affidavit. Yes. All right. 2 weeks further time is allowed for the opposite party number.
State and the both
for the opposite parties to file counter affidavit. Plus this case 2 weeks. You also file counter.
Yes.
Any action, I pray, any action as per page 42, 15/5/2024, the circle inspector approached the concerned SP and the inspector in charge regarding the activities of demolition and threatening the watchmen. So the no action is being taken. So that is the last occasion also directed the state council at least though concerned SP and IIC. So they are working under the state administration. So they will render protection to the monument. Only the conservation work the state government will undertake. But the protection part is concerned, the state government will look after it.
No, we are constructing the boundary wall. Somebody has broken it. We have reported the police. In this regard, we file the counter. We have started the construction work. They have demarcated. Under the construction, mid of the construction, somebody has looked.
Section 30 of the Monument Act says that any damage or spoliation or disfigure of the monument can be put to by criminal activities and prosecution can be launched against the
that we will see.
Item 47.
Open number 1, 2, and 3 mile.
Yes.
And here in this case, huge government land is involved. They are going
we'll file the counter affidavit by Tuesday, Your Lordship.
But
We'll file the counter affidavit by Tuesday, Your Lordship.
Tuesday.
Now 1 week after.
So I am for OP 10 to 13. And this, I have entered into the shoes after the insolvency resolution process on behalf of the successful resolution applicant. As your Lordship knows, this starts on a clean slate theory. Now, let's I have entered into the fray. Let's if your lordship may direct, I'll file my reply. Let's say which direction. If your lordship wants, I'll
No,
file.
your lordship, by the order dated 12/8/2024, specifically directed the government to file counter affidavit dealing specifically with communication made by the collector Cuttack addressed to the principal secretary to Government Industry Department Odisha dated 6/6/2020, Annexure 6 to the writ application. This is the specifically your lordship directed. So here the question, they are going to take alienate huge government land, more than 500 acres, and for private purpose in deviation of the purpose for which it was given, for industrial purpose. So it is this, and in 2020, collector Cuttack has specifically given a report that all these anomalies and they are going to alienate the property in paragraph 15, the apprehension of public regarding the sale of valuable government land to private person by the opinion of appeal.
Mr. Bali, she is seeking adjournment till Tuesday only. So should we deny that?
No, let them file their counter and serving a copy on me so that I can go to file my reply on.
We will see. By way of last indulgence, time till Wednesday is allowed for the state opposite, allowed to learn AGA to comply with this court's order dated 12/8/2024.
Plus in your lordship's
And also let them serve a copy of the counter on me.
lordship's prior order, as well as there was no notice issued to, there was no direction for me to file my reply.
So you can do that. If you are a party, you can do.
Your lordship.
You mean to say notice had not
2
been
weeks,
issued?
like
They
I
have
guess.
No. On the next day, we are not asking you to file counter affidavit. You will be at liberty to file.
And your lordship
You may decide to file after the counter affidavit is filed. That is up to you.
Your lordship may direct the government to serve a copy of the counter. Your lordship may
Serve a
direct.
copy.
Yes.
Item 48.
The affidavit has been filed.
Yes, I received it.
The journal also filed.
Yes. The
Journal filed by the OP. What is it?
yes, you have received the copy.
Yes,
You have received the.
No, this legend that is not there. And also the thing is that copy not served counter, therefore I said that I was prepared with it. Okay.
And the receipt is, I'm having.
Receipt having.
Yes, of the petitioner is for a San Sairat option notice was issued in 2020. Pursuant to which the petitioner submitted his bid. He became the highest bidder, and thereafter the agreement was executed under Annexure 5 on 19/2/2024.
Yes.
Thereafter, the mining officer under Annexure 6 directed for a physical verification of the sand sarat. In my presence, the sand sarat was physically verified by government officials and myself. Thereafter, the consent to operate order was passed by the.
What is Sarat, Mr. Sawant?
This is deposit of sand in the river bed.
Oh, no. What is the meaning of that word, Sarat?
Exactly, it is the government largest, which has to be.
Have you ever tried to find out the meaning of this?
I have never.
Please try. Please make your submission.
Okay. Thereafter, at page 50, then the mining officer allowed me to operate the sand source. That is on 22nd of March 2024. I made the road workable for the transportation
and started operation in first week of April 2024. Suddenly, on 22/6/2024, barely 2 months after, I have received a suspension notice. You are directed not to operate the sand source.
Why?
Then I made a representation to them. What is the reason why I will be debarred? Since they did not take any action, then I filed the writ application before this one. They have filed a counter affidavit. In the counter affidavit, they have stated that on a particular day, they have conducted an inquiry, that is annexure G/5 at page 33. A joint inquiry was conducted by the Tahsildar, Executive Engineer, RO, State Pollution. Your Lordship, I kindly have it marked to annexure G/5.
Yes.
At page 33. This is the letter of the mining officer cum competent authority, Tahsildar, Executive Engineer, RO, Joint Director, Chief Construction Engineer, Superintending Engineer, regarding joint inquiry of unlawful activities of Baitarani River sandbed, Baitarani River sandbed, Anandpur. And this letter was not forwarded to me. No inquiry was conducted in my presence or any intimation to me. And thereafter, they issued a show cause notice to me on 20th/6/2024. Well, let's see, that is at page 44, annexure J/5.
20th/6/2024 to 30.
26th of July 2024. This is the show cause notice issued to me. And pursuant to this notice, and again they also issued another notice at page 52. That is on 1/8/2024. This is annexure J/5. That is annexure L/5. Continuation of the show cause notice number so dated 26/7/2024. And to both the show cause notice, I have submitted my reply under annexure 11 to my rejoinder affidavit.
These notices were issued after filing of your writ application?
Yes, yes.
Okay.
During the pendency of the writ petition before this one. And I have submitted my reply annexure 11 to the rejoinder, and in paragraph 3rd page, I have stated on several occasions the government officials have filed FIR before the nearest police station that between the period 20 to 24, within the period for which I was not inducted as a lessee, some theft was taken place. Theft of sand has been taken place, for which the government officials have filed the FIR. And now they are attributing that quantity of sand I have lifted from the lease holder.
So you are not named in the FIR?
I have not been named in the FIR.
All right.
In FIR is before you got the lease.
FIR was dated 23. I got in April 24.
No, you got lease in 24 for the first time.
24 for the first time.
They are saying before you got the lease, you were operating the.
No. They are saying you must have lifted those sands from those adjoining.
Process start?
Process start.
No, when did the process start? Lease process?
4/4/2024.
No.
Advertisement was issued in February 2020.
Yes.
So that means.
But since the agreement, the requirement of pollution certificate and all of
So
they
have exercised which power?
By exercising section 51.
So you could have preferred appeal or revision, whatever.
Okay, 2020.
2020.
So when was it decided that it would be given to you?
April 2024.
24 is the agreement. Before that, advertisement of the year 2020.
Yes.
Thereafter, it must be decided that you are the highest bidder. So when was that?
That That was on 22/3/2024.
That also 24.
24.
So you could have preferred appeal against that order.
The proceeding is pending before them. That is
No,
not
no.
applicable.
Any order, which whether there is any order against you or not.
Now, under your lordship, I have pointed out that they have initiated a proceeding against me. That is pending before the.
There is an order suspending your mining operation also. So have you challenged that order?
That is not applicable.
That is not applicable.
No, ma'am. Your lordship, Annexure 10 at page 54.
No.
Rule 46 will not.
Rule 46 is there.
Rule 46 will not govern this matter.
Right?
This is not a final order. This is because during the pendence initiation of the proceeding, they have passed this order.
So therefore, we wanted to know in exercise of which power the order of suspension has been passed.
In exercise of power under section 51(1) and 51(4).
Let us see.
Your yours.
51 is penalty.
It's penalty.
There is suspension.
Whenever there is no suspension.
There is no suspension.
No, what suspension is not there. Neither in 51.
Anything. A stoppage or whatever.
Whenever any person is found extracting.
Is this your submission that there is no such power under the rules?
Yes.
You are not making this submission.
My entire endeavor is that. By invoking this power under section 51.
Yes, where is the power? There must be some power.
The notice under Annexure 10, they have mentioned 51(1) small I, 51(4) and 51(7). Let me place 51. Whenever any person is found extracting or transporting any minor mineral.
Please, this is penalty. Where is the power to suspend or cancel or whatever?
On my reading to the provision of this provision, 51(1), 4 or 7, there is no such power for suspension.
51 is penalty. 51 is criminal prosecution.
Yes.
51 is not.
They have, your lordship, kindly have a glance again to Annexure 10. They have only exercised the power under section 51.
Yes, let us see.
Will it be
Yes,
considered
yes.
That is because of 51. That is not under 51, rather because of 51.
Right.
Because you have violated the provisions punishable under section 51. Therefore, they have exercised that power. Where is that power to suspend? Let us see the order which you are referring to again.
Yes, with reference to page 54. With reference to the subject cited above, I am to say that a joint verification has been made on 21st of June 2020.
Therefore, you violating so and so. It is not that the order has been passed under these rules. It is because you have violated, which amounts to violation under those provisions.
What is the source of power, man?
Not to carry out, yes. This is the power 57.3. 57.3. Yes. And then you could have challenged that order.
And 57 power of entry and inspection. For any entry and inspection on the authority, at least a notice is required to be given to the lessee.
So therefore, you can challenge this. You can the submission which you are making, you can make before the appellate authority. And this has been violated.
It will not cover under section 46. Therefore, there is no.
How will it not cover?
So this says an order of the competent authority.
Right. If the order will be passed in the proceeding, which the mining officer has been initiated.
An order means any order. An order doesn't mean final order. You can file appeal.
On the submission before lordship, they have initiated a proceeding against me. I have already submitted my so-called reply. Let them dispose of that proceeding which they have initiated within a specified time. Until then, I may be allowed to operate my sanctuary.
No, till then there is an order not to operate. How can we?
All right, let them decide the matter within 15 days.
All right, 15 days. Tell us how much time will you take?
To obtain instruction.
Monday.
Monday.
This case on Monday, so as to enable an AGA to seek instruction as to the period in which the which is the communication by which action has been initiated. The next year? 4.
Next step 10 is the impugned order. At page 54, sorry, page 54.
54 is nothing, Mr. The safest course for you is to prefer an appeal. Let us see. So as to enable written counsel appearing on behalf of to be a period in which the inquiry which is being conducted against the petitioner as communicated to him through letter dated 22/6/2024 shall be completed.
The so-called notice is 26/7/2024, annexed J/5.
That is what we wanted to see.
Yes. Page 44 of the counter affidavit, annexed J/5. So-called notice to the petitioner.
Period in which the competent authority shall be taking a final decision pursuant to the so-called notice issued to the petitioner by later dated 26/7/2024 bracketed annexure J/5.
And 1/8/2024, annexure L/5. In continuation to that letter, the second letter was also issued at page 52. Continuance of so-called notice number so.
And 1/8/2024 bracketed L/5. Yes.
49.
For intervention because I am a successful bidder.
Yes.
Just now I received this line.
No, let us see whether you have any case or not. Notices are issued. Yes. All right, yes, counter has been filed.
Yes, no, contrary.
An intervention application has been filed by IA number 14378 of 2024.
It's 24.
This is 14378
Yes, ma'am.
on behalf of the successful bidder in opposition to the relief sought in the present writ application. So, considering the facts and circumstances, we are of the opinion that the intervention application deserves to be allowed. IA number so and so deserves to be allowed.
Just minute one. There is no document. He just claims to be a successful bidder. There is no document as such. And the government counter also doesn't disclose about the what has happened. So I just government counter also doesn't disclose anything, and in this counter they just say that I have been selected. No document.
Intervention application deserves to be allowed. So stop. When counsel appearing on I number so and so is accordingly allowed. Let OP number, let intervener so and so be impleted as OP number. Review the second OP. Next OP. When counsel appearing on behalf of the petitioner has, however, disputed the claim of the
no instruction on that. I'm not disputing.
Just a minute. When counsel appearing on behalf of the petitioner submits that he does not have instructions as to whether the newly added opposite party number 2 has been declared successful in the tender process, he shall be at liberty to file reply to the averments made in the intervention application. Stop. List this matter on week, 2 weeks. 2 weeks.
I have also filed another application.
Mr. Biswal, has this matter been listed on your mention memo?
I have given a memo to my.
What have you written in the memo?
In my associates.
You have to instruct your associates to be honest.
Yes, ma'am.
They have scored out your name from the mentioned memo. They have stated it is for the petitioner. And the prayer and the writ petition has been stated in the reason for listing.
I will tell them to show it. They have not shown me it. They have filed it.
Why have they scored out your name from the mentioned memo?
What is the name?
Is the intervener?
It's
not the petitioner.
And who has put this signature?
Madam.
Who has put this signature?
Can I?
Yes.
Can I see it?
No, it's not. It's not. Where is the original slip?
This is
No,
another one.
No, I have seen this. This might be a place.
What or there was the mention slip file?
No, I have told them to mention and list
You
it.
don't know anything about the memo?
No, my lord, I have no idea about this one because for that reason I want to see it who has signed it. So for that.
See it.
My lord. I only instructed them.
It's unfortunate if your associates are doing this without your knowledge. It will reflect upon you.
Yes, my lord, I will tell them. This is the signature of both new fellow 3 months there.
Very effective.
Yes, madam. I will tell them. I will be henceforth. I will be serious about that.
Henceforth you will be
It's the original I want to see. I had rejected, I think.
The memos which are given, what do you do with the
Just
memos?
memo.
You?
I'll check it.
Very good.
Item number 50.
Fine. There's my no problem.
Just.
Sorry.
Then do this. Yeah, how, was it listed yesterday or it has come up today?
It was not listed.
Not listed yesterday,
It's come up. No.
come up today.
Yes.
Yes, next.
Item 50.
Blank C. of the worksheets brief. And I filed an intervention below that for the subsequent successful bidder bills. And I filed that intervention bills are IA number 15513 of 2024. The since I am the L1 bidder bills, it will have a bearing on my case. That's what has happened. The accompanying with this writ petition bills has.
Who is for the petitioner? So what do you want?
I will detail the contribution to this intervention application.
Intervention you will see later, but
In fact, with your lordship's permission, may I just surprise, there was an NIT 863 that was floated by MCL. In that, this petitioner was awarded the contract for a particular number of years. Thereafter, another subsequent NIT 905 was floated. There, this petitioner for the same scope of work, only the quantity increased. Previously, it was 3.44 crores. Now it became 5.62 crores in the NIT 905. This petitioner has participated in NIT 905 for the same work. This is transportation of coal. For the same work, he has participated and has become joint L1 bidder together with. While participating in the subsequent bidder, in this writ petition, the petitioner prays that the remaining contract period, whatever is there under NIT 863, that should be granted to him without challenging this NIT 905. Now, what is happening in the meanwhile? I am sitting as an L1 bidder. I have all my machineries and everything at standby. I am keeping them engaged. Whenever the work gets issued, I will start working. Now, on one hand, this writ petition is pending. Because this writ petition is pending, perhaps I am given to understand that's why perhaps work order is not being issued. On the other hand, what is happening? In the petitioner's favor, limited tenders are being issued, which is of small amounts. As a result, what is happening? From my quota of assignment, this of the quantity, the amount is getting reduced. And since it is a limited tender, I am unable to participate in that because limited tenders, as the lordship knows. That's why I filed this intervention. I also filed a writ petition to challenging those limited tenders where it has been.
Where is your writ petition?
That writ petition, I filed a memo. I mentioned it before your lordship. I'm given to understand that matter will be listed on 2nd of December. It is writ petition 29333 of 2020. If my lord will call this
week of December, I must have.
I am for the MCL. Whatever facts my learned friend has stated is correct, except for the fact that his quota of amount is taken away by the limited tender. That is not correct. This is the same matter. If the lordship remembers, Mr. Prabhu Prasanna Bear was mentioning that I am ready to allow them to get the work, but I used to oppose each and every day. A NIT was floated that was given for 1 year, 365 days, with the condition, if required, we may give them for another 2 years. After that NIT for 1 year was completed, we granted them as per clause 5.3 additional quantity. After the additional, since why we granted it? Because another tenderer had challenged the LOA of this tenderer in another writ application. That was also before your lordship, and that was withdrawn because the new tender coming to place. Before the new tender in which he has the L1, the limited tenders were floated. Not that the amount of coal has been taken away from the new tender. Those limited tenders are independent than the new tender. The limited tenders have got nothing to do with the new tender.
So how many writ petitions are there?
One has been withdrawn. One is this writ petition. I don't know which is the writ petition.
It is Miller's writ petition 29.
I have no idea about that writ application.
It is not yet listed, Miller's.
29
of 24.
29 of 24. So let's just matter along with the other one. Right.
And WBC 13606 of 2024.
What? Yes, that is the writ petition. Lordship, I have maintained my counter. When one of the limited tender was floated, this petitioner challenged that. And once I went brought your lordship notice, yes,
They also pending.
Withdrawn it.
13606.
Yes.
13606 of 2024.
18516 not necessary.
That is withdrawn, but that has got a bearing in this tender.
That also come?
That is
disposed of.
Disposed of as
But that was filed challenging the L1 LOA of this tender.
That is disposed of on 27.
That may be tagged.
Along with the records of WPC number
The name is so
185.
distinct, I remember that other cases.
Lordship, I heard it 5 times.
Yes.
Let's just mark your lordship is rising. I would let's do the item 51. The next immediate next item.
We are ready to take up.
No, I'm sorry.
Whatever.
51.
Hello, your lordship will recollect. This is that matter where I was granted, let's say, quarry lease that was sandbed, quarry lease that was granted in my favor. Subsequently, what happened, Millers? If your lordship will kindly come to Millers, the environment environment impact assessment authority. That this what it did at page your lordship will see 34. Page 34.
Yes.
By virtue of this, Millers, what happened? The EC was transferred in my. Thereafter, Millers, letter of consent to establish, which your lordship will find at page 40, that was also issued to me on 3/5/2023.
So this cannot be heard today. No.
Only difficulty, Millers, is
Only difficulty is that have you seen how many adjournments we have sought in the present rate application?
in this.
Yes.
Millers, if I may just apprise your lordship.
Yes.
This matter, Millers, it came up for the first time. Your lordship
For the first time.
No, Millers, not today. Not today.
Yes.
It came up for the first time. For a prayer to dispose of my representative.
Annexure was incomplete.
Yes.
So you were granted time.
I filed that annexure. Thereafter, your lordships were of the opinion that your lordship needs to settle the law in this.
You wanted to file amendment petition.
Yes, Millers.
Then you wanted and today you want this petition to be taken up, heard and everything.
No, Millers.
We'll take up later.
Plus 2nd of December, my lease is.
You see, this is not.
Plus 2nd December.
No, sorry.
Can your lordship have it on Monday?
You see, let's discuss on Monday.
I'm so grateful. The counter has been received, Millers. I've received the counter. There is nothing in the counter, Millers. It's a bare bones counter.
Mr. Dalai was.
Lordship, please also
And
tell
he
you
was
Lordship.
there.
Lordship.
Very good.
Lordship had appointed him as the MIS.
Oh, yes.
I can assist.
We'll call the last one.
2nd December.
Item 52. Item number 52.
It was there online, not.
That will be next week.